procedural issues that we need to address from anyone? Not seeing any, we're going to go ahead and proceed. Let the record reflect that Senator Vandervoort is here with us this morning. And we're going to begin with the questions on commissioner questions. So let's see who's in the queue. Sigfer?
Thank you. Good morning, panel. Mr. Lucas, you had some discussion yesterday afternoon with Presiding Commissioner McKissick regarding the eligibility threshold criteria in the public staff's proposed Schedule LL. Do you recall?
Yes.
And you testified when he asked how many existing customers are above that 50 megawatt threshold. You testified yesterday afternoon that you did not have that number in front of you. Do you have it in front of you now?
Was it? I think that's on our table.
I'm sorry, sir. Please give me a mic.
Sure. Let me find the table. Let me talk to the rest of my panel here. Think we can get that number? Possibly.
Could you clarify, Ms. Press, if you mean like signed ESAs or like the broader pipeline in general, like what group, because we talked a lot about several different groups of customers, I believe.
And there will be several follow-up questions because I do think we need more clarity in the record. So thank you. We are going to get to exactly that distinction in just a moment. So Mr. Lucas, can you point me to the number?
We have a figure 2 that lays these out.
And you testified yesterday that you did not know how many existing customers already taking service from DEC were above the 50 megawatt peak demand threshold, correct?
That's correct. For existing customers, we do not.
You do not know.
For existing, yes.
And in response to another question from Presiding Commissioner McKissick, you testified regarding C&I customers and the impacts that they could potentially experience, but you also testified, and I think this is what your co-panelist was alluding to just a moment ago. You also testified regarding C&I impacts in the future customer ESA signed category, correct?
Yes, and that's what I was talking about previously a minute ago in our figure 2.
Okay, but your figure 2 does not address existing customers currently taking service from DEC.
That's correct.
Thank you. And would you agree with me, subject to check, that there are multiple existing customers taking service from DEC that have peak demands over 50 megawatts and a load factor over 80%?
Subject to check, yes.
And would you agree with me that it's important that we try to avoid unintended consequences here?
Yes.
Would you agree with me that it's important that we all understand exactly what impacts this may have on existing customers across the state of North Carolina before potentially implementing a solution that will throw the baby out with the bathwater?
I think we've evaluated that. We've got a large amount of load coming, and we are trying to get the future large load to pay a fair share of its costs. So we believe our tariff and our recommendations don't throw the baby out with the bathwater. We're trying to protect existing customers and make sure that future large loads pay their fair share.
And to be clear, our existing tariff is not proposing to include existing customers unless those existing customers had an incremental load increase of at least 50 megawatts.
And now that's different than what Mr. Lucas testified to yesterday. So let's explore that. Mr. Lucas, you testified yesterday, did you not, that the public staff would monitor existing customers' load and load profile characteristics and load factor characteristics, and that if an existing customer was behaving in such a way that you all felt it should be subject to this tariff, then you could potentially retroactively pull that existing customer onto the Schedule LL tariff. Did you not testify to that yesterday?
No, it did not. I said Duke Energy has to do that monitoring. And that's not in conflict with what we said. We've always, since yesterday morning, said incremental increases by an existing customer or 50 megawatts or more, and a load factor of 80%, over 80% would come under this tariff. I just want to make that clear.
Absolutely. And you also testified yesterday that even if there is not an incremental expansion, an existing customer over 50 megawatts and with a load factor above 80% may also be subject to Schedule LL under this monitoring framework that you are discussing.
We've asked Duke to monitor customers because we're concerned about customers gaming the system. Yeah, existing customers fall under the monitoring framework, but they would not fall under Schedule LL unless they had that incremental increase I just said. I'm
So-
sorry if I wasn't clear, but I think I've just made it clear.
Mr. Lucas, in response to questions from Presiding Commissioner McKissick, I think I heard you testify yesterday afternoon that large load customers should file a plan with this commission for how they plan to manage sudden disconnections and reconnections. Did I hear you correctly?
No, they should file it with Duke Energy and Duke Energy should approve it. And that's in our tariff. You can go to that section of the tariff if you want to.
So just to be clear, you said a customer should submit that plan to Duke Energy, not to the commission, correct?
I hope that's what I said, and that's on the last page of our tariff. This is large load panel exhibit 3, page 404. It's the very first paragraph. It says the customer must provide a written plan to the company regarding sudden disconnection and reconnection.
Thank you. I just wanted to clarify
Okay.
that. Also in response to a question from Presiding Commissioner McKissick regarding potential consequences for a large load customer that fails to adhere to a plan for managing sudden disconnections and reconnections, you testified that customers will be aware in advance of any new requirements ahead of time, correct?
Of requirements, yes.
And this is DEC's rate case, correct?
Yes.
Duke Energy Progress is not a party to this proceeding, are they?
No.
And Duke Energy Progress's customers have not yet had an opportunity to be heard regarding the public staff's proposed Schedule LL, correct?
Yeah, we haven't had that hearing yet. We had the same requirement in our DEP testimony as well.
And to your knowledge, do other interveners have a chance to provide supplemental or rebuttal testimony in response to the public staff's recommendations?
No.
Mr. Lucas, you were asked some questions by Commissioner Tucker regarding HR 9340, the Ratepayer Protection Act. Do you recall?
Yes.
Are you aware of the definition for large load set forth in that bill?
I don't recall what that definition is in that bill.
Presiding Commissioner McKissick, I don't have any further questions at this time, but with respect to the late filed exhibit that the commission requested from the public staff, Sigford does respectfully request the opportunity to further cross-examine these witnesses once that exhibit has been filed. And therefore, we would ask that this panel not be excused until such time.
Duly noted.
Thank you.
The next in the queue, CUCA. No questions. Environmental Defense Fund.
Just a couple. Sorry, Ben. Ben Smith for the Environmental Defense Fund. Good morning. Do you call yesterday? Commissioner Tucker asked you about President Trump's ratepayer protection pledge,
Yes.
and you all testified a bit to it in your direct testimony. Isn't that right?
Yes.
And is it your position that to achieve the goals of the ratepayer protection pledge, the proposed Schedule LL is something that's necessary?
Yes. And Schedule L is not only to meet the ratepayer protection pledge, it's, without that ratepayer protection pledge, we would have pushed forward this schedule.
And I can't recall which commissioner brought it up, but Council Kress for Stickford just brought up the timing to review a Schedule LL and the fact that you don't have the ability to file rebuttal testimony. You recall that?
Yes,
Subject to check, the technical conference on large load occurred in October of 2025. Is that right?
yes.
And during that presentation, did Dustin Metz make reference to the fact that the companies needed to consider a large load tariff?
I don't remember that, but in our initial comments filed in August of 2025, we do recommend consideration of a large load tariff.
If Mr. Metz didn't discuss it, I'm sure the panel as a whole did during that presentation.
Thanks. No further questions.
Thank you. Google.
No questions. Thank you.
Oh, questions, okay. Microsoft.
Good morning. Ben Snowden here on behalf of Microsoft. Yesterday afternoon, Commissioner Tucker asked a number of questions about the potential for large load customers to pay for network upgrades, and he specifically referenced Microsoft and the other large load customers in this hearing. Do you recall that?
Yes,
Okay, and you recall Commissioner Vandervaart also asked some questions about funding system improvements required for data centers while protecting ratepayers. You recall that too?
yes.
Okay. Have you all reviewed the testimony of Microsoft's witness, Isaac Gable-Frank, in this case?
Yes.
Did you review Microsoft's motion for an expedited docket to consider large load issues?
I believe, I can't remember exactly, but that was in someone's testimony. It could have been Microsoft. I remember that request.
Okay. Would you agree that in its filings, Microsoft does not oppose the development of a large load tariff?
I can't remember that statement. But it would make sense if they push for expedited large load tariff, they're not opposed to a large load tariff.
And so you'd agree that, in fact, witness Gable-Frank recommends in his testimony that the commission initiate an expedited proceeding to develop a large load tariff with input from stakeholders?
That's what I don't remember those exact words. I've read a lot of testimony from a lot of people. So,
Okay.
but subject to check, I would
Mhm.
agree with you.
Okay, all right. Subject to check, and I've got a copy of his testimony if you'd like to look at it, but subject to check. In its motion, Microsoft proposed an expedited stakeholder process in a dedicated docket with defined timelines to develop a comprehensive large load tariff.
Subject to check.
Okay. And in its motion, when you would agree that Microsoft notes that,
Apologies, Commissioner. Can council identify again which commission question this was related to? I do not recall this Microsoft motion being the topic of discussion on questions on commission's questions yesterday.
I would concur. Mr. Snowden, can you identify which question?
yes, sir. Well, there was, I can pull up the exact questions, but Commissioner Tucker asked a fairly long series of questions about ratepayer protections and specifically about the involvement of Microsoft and the other large load customers that are
I thought that was when he was discussing the president's
the president's ratepayer protection.
ratepayer
pledge. Yes,
protection.
I can skip the large load tariff stuff and move directly to the
I would
mechanisms.
do that if you would, sir.
Okay.
I think that's more appropriate. I want to
Okay.
get back into it.
Okay. All right. Mr. Lucas, would you agree that Mr. Gable-Frank in his testimony, he testifies about mechanisms that would allow customers to more directly manage the costs, would allow large load customers to more directly manage the costs associated with serving their load while also limiting cost impacts to non-participating customers?
I can't remember all that
Okay.
testimony. If you have,
Okay. Yeah, I've got a copy. If you
okay, I feel more comfortable asking you a lot of questions about your witness's testimony.
By all means. And can you identify for purpose of the record, the document that you have presented to the witness to review?
Yes, Presiding Commissioner, that is the direct testimony of Microsoft witness Isaac Gable Frank, filed, I believe it was on May 29th.
Thank you.
So
do you
yeah,
see
do
that?
The page and line.
Sure. Let's look at page 16, for the bulk of page 16. Mr. Gable Frank testifies about mechanisms that allow customers to more directly manage the costs associated with serving their load while also limiting cost impacts to non-participating customers. Do you see that?
Yes,
Okay. And one example Mr. Gable Frank provides is a customer-driven framework that allows new or expanding load to be served through resources or arrangements supported directly by the participating customer. That's on lines 9 through 23, I believe. Page
see it there,
16.
16 through 18, yes.
Okay. And those would include arrangements between the customer and the utility or other entities to support specific resource additions or infrastructure that are needed to serve that load. Do you see that? That's
Yes,
on,
I see that. I see that.
and this is on page 17, lines 14 through 17. Mr. Gable Frank specifically recommends that the commission direct Duke to open an expedited stakeholder process to evaluate the role of customer-driven mechanisms to support load growth while managing cost impacts. Do you see that?
Yes.
Presiding Commissioner, I think these would be great questions for witness Gable Frank when they are here to testify before the commission. If the commission has questions about recommendations, that would be great for those to be elicited between the witness. But to ask Mr. Lucas about Mr. Gable Frank's testimony under the context of the president's ratepayer protection pledge seems a little bit far afield from.
I would concur.
Commissioner McKissick, if I
Yes,
may.
if you could, yeah.
Yes, I mean, these are, again, and I have only one more question.
Okay.
But Microsoft's involvement in the state of North Carolina was specifically called out. And so I am listening to, and these recommendations are certainly germane to the ratepayer protection pledge and the subject of those questions from both Commissioner Tucker and Commissioner Vandervaart.
To the extent you have only one more
Yes, sir.
question, ask that last question and move on to whatever additional information you'd like to get from this particular panel.
Okay, thank you. Would the public staff support Mr. Gable Frank's recommendation that the commission direct Duke to open an expedited stakeholder process to evaluate the role of customer-driven mechanisms to support load growth while managing cost impacts to customers?
I can't say that. We would have to discuss that internally. But our proposal is for the commission to adopt our tariff, our changes to the service regulations and the ESA application as we filed them. That kind of decision would require more discussion than what we can develop here on the witness stand.
Okay, thank you. Those are all my questions.
Thank you. North Carolina Justice Center et al., if you have questions.
Presiding Commissioner McKissick, no questions.
All right. Nucor, if there are questions. And Walmart.
I do. I'd be happy to switch places with Mr. Snowden unless you guys are comfortable with me being right here. I think most of my questions are for you, Mr. Lucas. I just want to clarify the record. You had a discussion with Presiding Commissioner McKissick yesterday where you were asked about the 50 megawatt threshold that you all have proposed in your proposed large load tariff. And I think you specifically were discussing page 27 of your direct testimony. And then in the context of those discussions, you were asked specifically about other large load tariffs that you had looked at. And then later on, Commissioner Vandervaart asked you some questions that specifically caused you to discuss Dominion Energy Virginia's GS5 tariff. And I believe I saw you pick up a copy of that tariff. Do you recall those two sets of questions?
Yes.
I just want to clarify for the record. So Ohio's scheduled DCT or data center tariff, you agree with me that that is a data center only tariff that applies to data centers and cryptocurrency miners at load 25 megawatts or above?
We have some of the statistics on that tariff, but I don't believe, and my panel can find, I don't believe we have that information if it's aimed only at data centers. If it include any other customer class, I'm not aware of it.
Can you agree subject to check?
Yeah, I'll agree subject to check.
Okay, and then I believe in response to Commissioner Vandervaart's question, you said that Dominion's scheduled GS5 was specifically aimed at data centers.
I believe I did, but I've got that schedule and we can confirm that right now if you wish.
I would. I just want you to agree that in fact it applies to all customers who meet the size and load thresholds. Not that I'd like to spend any more time on GS5 than I already have, but
Yeah, I've got a copy of the final order from Virginia State Corporation Commission, case number PUR 2025-00058, and I've got the paragraphs related, and it's not aimed only at data centers. It describes some very data center-like characteristics, but does not say, as far as I can tell, that it's aimed only at data centers.
and were you aware that parties like Walmart in that case proposed that the tariff threshold, number one, should not apply to all customers and should not apply at the 25 megawatt threshold, but what should be a higher threshold, such as commission staff has proposed in this case?
I was not aware of Walmart's position in that case.
And were you aware that in the most recent legislative session before the Virginia General Assembly, that sort of a carve out was proposed to GS5 and signed into law by Virginia's governor to exempt certain non-data center customers, 25 megawatts to 50 megawatts, from the applicability of tariff GS5?
We've had some of those discussions in the public staff, but I cannot testify under oath that I've seen that change in legislation.
Thank you. Those are all the questions that I have.
Okay, public staff.
Thank you, Presiding Commissioner. Panel, on the question from Commissioner McKissick yesterday regarding existing commercial and industrial customers meeting the 50 megawatt threshold. And to the extent that your testimony was unclear regarding your recommendation for Duke monitoring characteristics of those customers, can you turn to page 39 of your corrected testimony, lines 14 through 19, and confirm whether that read it, please, and then confirm whether that is still your testimony and recommendation to this commission?
Lines 14 through 19.
That's correct. Beginning with we also.
We also recommend that the commission require DEC to monitor the load characteristics of new customers whose load and load factor meet the criteria for Schedule LL, and require those customers to begin using Schedule LL at such time as they meet the Schedule LL qualifications.
And I could add a little bit. One thing we've asked for in our testimony is that if Duke signs an ESA, that they file it very soon after signing the ESA, and the public staff will review those ESAs. I'm sorry if I was unclear, but there is that request in our testimony.
Okay. And so just to confirm, this is still the recommendation of this panel?
Yes.
And this recommendation applies to new customers rather than existing customers. Is that correct?
I'm sorry, tell me a specific recommendation you're talking about, the one that Mr. Sankanji just read?
Correct.
Yes, yes.
Thank you for that. So I switch gears here. Dr. Weaver, Commissioner McKissick asked you yesterday what the average megawatt threshold was for the tariffs you reviewed in the docket E100 sub 208 proceeding. As you mentioned on page 27 of your testimony, are you able to provide that number to the commission today?
Yes, so just for the clarity of the record, since I believe counsel for NCJC et al. Was also asking a few questions about this, the average that I'm presenting to you in a second here is based on a subset of the tariffs we reviewed, because I focused on only the currently approved tariffs. And there are a few duplicates in that list in terms of tariffs that had multiple tiers or providing information for multiple tiers. So this is only 23 of those tariffs, but they're all currently approved. So the mean I'm referring to in testimony is a mean of 36 megawatts. The median value was 25, and then the range, the minimum and maximum of those tariffs was 0.5 megawatts up to 150 megawatts. So that 500 megawatt value that NCJC had referred to, I don't believe that tariff has been approved, at least at the time that I was calculating this.
Dr. Singanzi, Commissioner Tucker, yesterday asked you a question regarding the 6 large load customer subgroup that had facilities charges that were included or proposed to be included in this rate case. Do you recall that question?
Yes.
And I believe in your discussion, there was some discussion or characterization of all 6 of those customers being data centers. Can you clarify the composition of those 6 particular customers that you discuss in your testimony?
Yes, to clarify, the 6 customers that we were referring to that we can see in figure 4 on page 48. Not all of these projects or customers are data centers, but the vast majority of the costs that are requested for are of data center characterization load.
All right, thank you, Presiding Commissioner. Those are our questions.
Thank you. Well, let me thank you for your testimony. I know you were there all day yesterday, so I'm sure that intellectually it was probably quite exhausting, but we appreciate your capacity to contribute and provide information that will be insightful to the commission as we move forward with our deliberations. You will not be released at this time because of the potential for recall once that late file exhibit comes in, but otherwise, I'm sure we'll be particularly seeing some of you as things move forward. Thank you. And once they transition, we'll be ready for the next panel.
And Presiding Commissioner, that next panel will be Chris Walters and Patrick Fahey.
All right. Did you work out those logistical challenges with people appearing in certain orders?
Yes, Presiding Commissioner, we did. Thank you.
Okay.
Apologies for not offering clarification
Okay.
earlier, but we are ready to proceed as planned.
Excellent. Thank you.
Older. Oh, we were just working out special stuff. Just so pleased for the. Other than that, just didn't wait.
Looks like everybody is now successfully transitioned. So if you would put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
I do.
Thank you. Mr.
Thank-
Freeman, go right
Thank you,
ahead.
Presiding Commissioner
Sure.
McKissick and Commissioners. I'm Will Freeman, and with me is Jennifer Harrod. We're attorneys with the public staff here on behalf of the using and consuming public. I would now propose to move these witnesses' testimony to the record unless the commission has a different.
That would be perfect. Perfect
you.
timing.
Mr. Walters, let's start with you. Could you please state your name, business address, and current position for the record?
My name is Christopher Walters. My business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017. I'm employed at the firm Brubaker and Associates Incorporated, and I'm a principal of the firm.
Thank you. Mr. Walters, on May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 134 pages, 1 appendix, and 17 exhibits?
Yes,
Did your testimony contain confidential information?
I don't believe so.
Your testimony did not contain confidential information, correct?
It did not contain
On
confidential information.
June 19th, 2026, did you prepare and cause to be filed an errata and corrections to your pre-filed direct testimony and corrections to your exhibits CCW 14 and CCW 17?
Yes,
On July 10th, 2026, did you prepare and cause to be pre-filed an errata and second set of corrections to your pre-filed direct testimony?
yes,
Do your corrections change your recommendations in this case?
they do not.
Do you have any additional corrections to your pre-filed direct testimony?
Not to my knowledge.
If I were to ask you the same questions in your corrected pre-filed direct testimony today while you're under oath and appearing here at the witness stand, would you give the same answers?
Yes, I would.
Did you prepare and cause to be pre-filed on July 6, 2026, a summary of your testimony in docket number E7 sub 1329A?
Yes,
Thank you. Presiding Commissioner McKissick, I would respectfully request and move that Mr. Walters's pre-filed direct testimony, including his appendix, with that testimony as corrected, be accepted and entered into evidence and copied into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you. I would also, Presiding Commissioner McKissick, respectfully request and move that Mr. Walters's pre-filed exhibits as corrected, as the two with corrections, be marked in the manner as they were when pre-filed. And are we moving them in now? Or should I-
Yes, you can go.
Okay. Then I would also further respectfully request to move they be entered into evidence and copied into the record.
Without objection, your motion is allowed.
Thank you.
Commissioner McKissick, there are 3 sets of testimony from Mr. Walters, a direct, a first corrected, and a second corrected. Mr. Freeman only made 1 motion, and I'm wondering which one you're putting on before us.
I would, the correction filed on July 10th has all the corrections. It's the comprehensive one. So I would move the July 10th testimony, the exhibits filed on May 29th, and then we corrected exhibits 14 and 17 on June 19th. So
Okay, so basically we need all 3 files up.
I'm glad to file all 3 as well, Commissioner, Chairman. I would, if I were wanting to follow along this testimony as questions were asked, I might pull up the
Most
July
recently.
10th testimony.
All right, thank you.
Thank you.
Yeah. So as it stands at this point, the July 10th was the one you were referring to, which was the one that incorporates all of the potential, or all of the actual changes that were made.
Yes, thank you, Commissioner.
Okay. So let's make sure that's clear for purposes of the record.
Um,
And without objection, your motion is allowed.
Thank you. Mr. Fahey, if we could turn to you now, could you please state your name, business address, and current position?
My name is Patrick Fahey. My business address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm a public utilities regulatory analyst within the energy division of the public staff.
Thank you. On May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 92 pages, 3 appendices, and 1 exhibit?
Yes.
Did your testimony contain confidential information?
No.
Do you have any corrections to your pre-filed direct joint testimony?
No.
If I were to ask you the same questions in your pre-filed direct testimony today while you're under oath and appearing here on the witness stand, would your answers be the same?
Yes.
Did you prepare and cause to be pre-filed on July 6, 2026, a summary of your testimony in docket number E7 sub 1329A?
Yes.
Presiding Commissioner McKissick, I would respectfully request and move that Mr. Fahey's pre-filed direct testimony, including his appendices, be accepted and entered into evidence and copied into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you. Presiding Commissioner McKissick, I would also respectfully request and move that Mr. Fahey's pre-filed exhibit be marked in the manner as it was when it was filed, and I would further respectfully request and move that it be entered into evidence and copied into the record at this point.
Without objection, your motion is allowed.
Thank you. Presiding Commissioner McKissick, these witnesses are now available for examination, cross-examination, and questions on commission and commission questions.
All right, the Attorney General's office, do you have questions to this?
I have no questions at this time, but reserve the right to ask questions on any commission.
All right, very good. Sigford,
No questions. Thank you.
CUCA,
Christopher Dodd, we have CCA, no questions.
no questions. Environmental Defense Fund,
No questions.
North Carolina Justice Center et al.
So no questions at this time, but would also reserve the right to ask questions on commission questions. Thank you.
Okay, Walmart,
No questions, Your Honor.
okay, DEC,
Thank you, Commissioner McKissick. I had prepared all kinds of objections to friendly cross and now I don't have to use them anymore, which is wonderful. Good morning, and good to see you again, Mr. Walters. And good morning, Mr. Fahey. I'm not sure I have seen you before, but if I have, I've forgotten and I apologize for that. Mr. Walters, let me start with you. And I'm looking at page 103 of your original testimony. I think that it won't change in the most recent corrected version. But right at the top of the page, there's a question that says, question, are you recommending an adjustment to DEC's capital structure? Do you see that?
That is on a different page. Didn't the copy I have.
What page is it on in the July?
In the July 10, the question, are you recommending an adjustment to DEC's capital structure, appears on line 7 of page 98.
Okay.
No idea what happened there.
All right. Well, anyway, that's the question I want to focus on,
Okay.
at least to begin with. And you conclude in your answer to this question that the proposed 53% equity, 47% debt capital structure, long-term debt capital structure is excessive. Is that a fair characterization of your answer?
I would say that is a fair characterization.
And you state that the 53% equity pad is, quote, significantly higher than the proxy group's equity ratio of 42.3%, excluding short-term debt, close quote, correct?
Correct.
And you state that, quote, additionally, DEC's credit rating from Moody's is 3 notches higher than the proxy group, indicating a significant difference in overall risk, close quote. Is that what you said?
Yes.
Now, your proxy group is the same, I think, as DEC witness Coyne's proxy group, at least from his rebuttal testimony after he removed a company or two due to merger-related activity, correct?
That sounds correct.
And every single one of the companies in your proxy group is a publicly traded utility holding company, is it not?
They are.
And every single one of those publicly traded holding companies has one or more operating utility subsidiaries, correct?
I would agree with that. Yes.
And that's the same basic corporate structure as the relationship between Duke Energy Corporation, a publicly traded holding company, and Duke Energy Carolinas, its wholly owned utility operating subsidiary.
Correct.
Now, your recommended capital structure for DEC is 51% equity and 49% long-term debt, correct?
Correct.
Mr. Walters, I think that the appropriate capital structure comparison is between DEC, the operating company, and your proxy group of holding companies. Why don't you recommend the 42% equity ratio that is reflected in your testimony for the holding companies?
I appreciate the question. I don't take just into consideration the proxy group's equity ratio. I also take a look at industry standards, and then I also measure the financial integrity at a reasonable capital structure as well. So while there might be some electric utilities out there that do have equity ratios as low as 40-something, low 40%, that's not standard. And I think it would also be a significant hit. I don't know that DEC's financial integrity could uphold a 42 or 41% equity ratio. And I'm confident that they'll be able to at my recommendation with a 51% equity ratio.
And so you're saying that the standard nature of the proposed capital structure is something that's important? That's standard versus the industry?
I think, looking or referring to observable benchmarks such as the average or median authorized equity ratio, and taking into consideration facts and circumstances of the case, and where the financial integrity of the company is now, where it could be, are all taken into consideration, as well as the equity ratios of the proxy group used to estimate the cost of equity for DEC in the instant proceeding.
Mr. Walters, I'm not sure that there should be a notebook up there somewhere with the DEC proposed cross-examination exhibits.
Mr. Walters, will you pull the microphone right up to your mouth while you look for that notebook?
Sure.
And if it's not up there, we'll get it to you.
Which particular exhibit number was that?
Number 2.
Number 2?
Commissioner McKissick.
Thank you.
Thank you. Forgive me, Mr. Mehta, what was the?
Number 2.
Can you confirm what that one is? Is this the,
So that should be the commission's order in the immediately preceding DEC rate case, E-7 sub 1276. Is that what you've got?
Sorry, I was looking at the top, sub 1134. I see sub 1276 now.
Okay.
Thanks.
And Commissioner McKissick, since this is a commission order, I'm not going to ask that it be introduced into evidence, but it's a commission order, so
Exactly.
we can all refer to it whenever we want to refer to it in briefing, orders, proposed orders, etc. Mr. Walters, would you turn to page 224 of the commission's order in the last case?
$224?
Yes, sir. And if you would look with me at the second full paragraph on that page, it's one that begins, "As for witness Walters."
Over there.
You see that? What the commission said in its prior order, I'll read it to you. You tell me if I read it correctly. I won't read the citations just because it gets awkward.
Understood.
As for witness Walters, much of his testimony in support of lowering the equity layer from DEC's request is premised upon comparisons to the capital structures of publicly traded holding companies. The commission has repeatedly rejected the use of holding company capital structures in the past. Do you see that?
I do.
And the citation there is to a case from the commission involving the DEC request for increase in rates in 2009, correct?
Yes.
So the commission has rejected your idea that the appropriate cap structure comparison is to publicly traded utility companies in precedents stretching back to 2009, correct? At least 2009.
That is true, but again, this commission's not required to adhere to any prior commission orders. They can make their own opinions and orders as they see fit based on the facts and circumstances before them in this case.
Okay, but to the extent that the commission wishes to honor its own precedents, those precedents go back to at least 2009, almost 20 years ago, on the point that we're discussing.
I would agree, but I want to emphasize that the first sentence says much of his testimony, which is also partly the case right now. As I told you, I didn't just consider the capital structures of the publicly traded utility holding companies, which their average equity ratio is in the low 40%, around 42 or 43. I'm recommending nowhere near an equity ratio of 42 or 43%.
But in the last case, you recommended an equity ratio of 52%, did you not?
I did, and in this case, not only did the proxy group average equity ratio decline, so did the industry average of medians relative to the DEC, relative to the averages in the previous case.
Mr. Walters, let's move to a different topic.
Okay.
Again, I'm going to give you a page reference in your testimony, but it's to the original testimony, and hopefully we can find where it is in the July 7th.
Can I put this binder away for now?
I'll keep it close. Just keep it handy. And I'm looking at page 27 of the May 29th testimony, and specifically at figure CWW-5. So I think we could probably find CWW-5, figure 5, even if we can't find the page.
I can find CCW5 and not CWW5.
All right.
And it is on the page you referenced.
I must apologize, Mr. Walters. I had a mentor whose name was Clarence W. Walker, and his initials were CWW, and it's a little too close to CCW, but
I understand.
that's where we are.
I can appreciate that.
Also known as Ace Walker, but maybe he didn't like Clarence. Anyway, CCW 5.
I'm there.
I unfortunately am not, but I'll get there. And Mr. Walters, if I'm understanding this figure correctly, you are comparing the actual 30-year Treasury bond yield versus consensus projections of that yield on both a shorter term basis and a longer term basis.
Correct. The consensus projections come from the Blue Chip Financial Forecast and Economic Indicators publications. The longer term projections, the 5 to 10 year, are produced much less frequently. The near term consensus projected is about 6 quarters out into the future at the point in time of the publication.
Is it fair to say, looking at your figure CCW5, that really since the first quarter of 2023, actual 30-year Treasury bond yields have outpaced projected yields on both a near-term consensus and long-term consensus basis?
I would agree that generally there's a couple instances where that's not the case, but generally I would agree with that assessment.
Mr. Walters, is it fair to say that one of the principal pillars of the HOPE Bluefield standard is that the rate of return should be set at a level comparable to the returns required on investments of similar risk?
That's one of them, yes.
Well, if you turn, and again, I'm going to reference the May 29th testimony, but I'm sure we can find the same testimony in the July 10th version. Page 43 of the May 29th testimony.
I'm at page 43.
And at least at the top of the page that I have, there is a citation to both the Bluefield and HOPE cases. Does that work with your current version?
I've got that on page 42.
All right, well, let's just go there then.
Interesting.
Well, I mean, but it starts on 41, if that's what it's, but the actual citations are on 42.
But immediately following the citations, you state a utility, not immediately following, but shortly thereafter. The Supreme Court also found that, quote, "A utility is entitled to such rates as would permit it to earn a return on property devoted to the convenience of the public that is generally consistent with the same returns available in other investments of corresponding risk." Do you see that?
Okay, so that's on page 41 of the July 10 edition, line 20. I see what I agree with what you read.
And is what you meant by that statement that, to go back to my original question, one of the pillars of the Hope Bluefield analysis is that the rate of return should be set at a level comparable to the returns required for investments of similar risk?
Yes.
Isn't it true, Mr. Walters, that water utilities are generally considered to be lower risk than vertically integrated electric utilities?
Generally, I mean, there's certainly going to be instances where some water utility might be considered riskier, but as a whole, I would agree that's probably a general understanding. But that's assuming, a whole other slew of factors.
But as a general proposition, you would agree that water utilities are lower risk than vertically integrated electric utilities, especially those vertically integrated electric utilities that operate nuclear generation?
It's a nuanced question because, I mean, if, for instance, there's so many different measures of risk, and one particular measure of risk specific to water utilities or vertically integrated electric utilities would be a firm's beta. And water utility betas, which measures the market risk of a publicly traded security, is generally consistent with many electric utility holding companies, including Duke's, which I believe is 0.65 at the present. So that's an adjusted beta from value line, of course. So it depends on what measure, but as a general proposition, when you look at like authorized ROEs, electric utilities generally are awarded ROEs higher than, but there's also less frequent water cases. There could be more settlements. Outliers could also drive them up or down. So I'd say it's nuanced, but generally I would say that that's probably true.
Thank you. Commissioner McKissick, I have no further questions.
All right. It looks as if at this point in time, redirect.
Thank you. I have no redirect, Commissioner.
All right, we do have a number of questions from commission staff. I think it's 19 to be exact. It does not include the subparts. So position yourself to provide concise answers. They need not be exhaustive answers, but do your best with it. Mr. Walters, you note in table CCW1 on page 12 of your testimony that 24% of authorized ROE decisions were less than 9.5% in 2025. What about DEC justifies an ROE that is less than the 9.78 average for 2025 and in the minority of recent ROE decisions?
Thank you for the question. I appreciate the opportunity. I would refer you to my exhibit CCW2, where I compare Duke Energy's DEC's credit ratings and equity ratio relative to the proxy group. So the proxy group is just used as a group of companies to estimate the cost of equity, and then you have an indicated range out of that based on the model results. And then from there, I take into consideration the relative risk of the company within that of the proxy group. If they're above average risk, there's something that could warrant an ROE above the midpoint of that indicated range. If they're below average risk, something in the lower half of that range is indicated. And I believe that we are in that lower half of the range at this time. And that's, as you would see on exhibit CCW2, and as discussed in my testimony, Duke Energy Carolinas has a 3-notch credit rating advantage relative to the proxy group, which is unarguably indicative of lower relative risk to the proxy group. And again, you're using these proxy companies to estimate the cost of equity, so their book value capital structure is relevant. And Duke Energy Carolinas has a much higher equity ratio than that of the proxy group. Additionally, and as discussed by Mr. Fahey, they have a whole suite of risk mitigators and alternative forms of rate making that significantly reduce the risk. I don't know if Mr. Fahey has any additional thoughts on that as far as risk comparability is concerned, but that's before I pass it over. Sorry, Mr. Fahey. I would also note that the cost of equity is a forward-looking process, whereas in that table, we're looking at historical averages. So while it's an observable benchmark, that's not necessarily indicative of forward-looking cost that's present in the market data that I relied on. Thank you.
Mr. Fahey, do you have anything to add?
I would just add that in my viewpoint, that lower half of his range, that sort of lower risk is viewed in that we have regulatory mechanisms that are not common among the many other states.
Okay. Now, Mr. Walters, your table notes a cutoff date of March 27th, 2026. How is your table impacted by ROE decisions since that point in time?
I cannot give you a definitive answer. I think the average has gone, actually I don't know that RRA has published their most recent report through the second quarter. I can't give you a definitive answer. I can follow up if you would like, but I don't know that
I'll put it like, I think that your response is adequate.
I know I probably updated this in my DEP testimony that was recently filed, but I don't have that number on top of mind.
Do not have that number on top of mind,
No,
but you believe it is in your DEP testimony.
it would have been updated because I had different study dates for both of those testimonies, given the length of time between them. But I don't know off top of mind how the distribution of those authorized ROEs are at the moment.
Okay, thank you. Now, Mr. Walters, in the prior DEC rate case, the commission declined to accept your sustainable growth and multi-stage DCF results. Why should the commission give weight to these models in the current proceeding?
If I remember the order correctly, the commission stated that I did not give much weight or any weight to them, and therefore they declined to do so as well. Be that as it may, I don't know that that's necessarily an accurate assessment. But if we look, the growth rates are really what's driving the DCF results at present, especially in the constant growth model, assuming analyst growth rates. I think in the prior case, those analyst growth rates for utilities were much more in line with GDP growth, whereas here they're 70–80% higher than GDP growth, which is just an unsustainable it's economically unfeasible. It's well documented in financial and academic literature that no company or sector can outgrow GDP in perpetuity. And perpetuity is the time period assumed in the constant growth model. So you're taking 3 to 5 year growth rate estimates that are almost twice as much as the expected growth of the GDP in the economy in which they provide goods and services. So you have to take that into consideration, and the sustainable growth and multi-stage models are certainly ways to do that.
All right. Now, Mr. Walters, in your risk premium analysis, you use the difference between annual authorized ROEs and U.S. Treasury yields. Why did you use annual results instead of more granular data?
I use annual results because there's a lot less noise, if you will. If you use single observations or even quarterly observations, there could be outliers that significantly drive those that aren't necessarily representative of the industry as a whole in that particular period. For instance, it could be in the instance of a quarter where there was only one ROE decision. from one jurisdiction that tends to be either very high or very low on authorized ROEs, that could really skew the data. So it's my opinion that using annual averages is more representative, and it provides a smoother, clearer picture, that's less driven by outliers and noise.
Okay, now Mr. Walters, in his rebuttal testimony, DEC witness Coyote okay, I mispronounced it, excuse me, criticizes your WLS risk premium analysis. What is your response to his criticism?
I would like to know which specific criticism. I can discuss why I believe the WLS, or the weighted least squares regression models, far superior than the regular ordinary least squares regression model. The weighted least squares regression model gives more weight to more recent observations, whereas in the ordinary least squares regression analysis, Mr. Coyne gives equal weight to equity risk premiums from the early 1990s than as he gives weight to them today. And as I demonstrated through particular statistical analyses, that the ordinary least squares assumption that the slope and the relationship is stable, it is not stable. And the ordinary least squares regression analysis that Mr. Coyne employs understates the slope, or how much the equity risk premium changes with interest rates. His analysis, I believe, is around, give or take, for every 100 basis point increase or change in interest rates, the equity risk premium changes by about 45 or 50 basis points. And that's true if you look back prior to the early 2000s, but and in my testimony, I identify 6 specific years that I analyzed where the you analyze the slope before that year and the slope after that year in an ordinary least squares regression, and that slope nearly doubles, meaning the interest rates, for every 100 basis point change in interest rates, the equity risk premium almost changes 80 or 90 basis points. So they're much more reactive at present. So that's why, and that could be due to a whole slew of factors, due to economic changes, regulatory regime changes, a whole number of things. We're seeing commissions, ROEs, the equity risk premium is squeezing, meaning smaller, even though interest rates have risen in the last couple of years. And that's because of all these other nuances that commissions are taking into consideration when they're authorizing ROEs. The ROE isn't increasing as much as interest rates. So that's why it's got that pressure on the equity risk premium.
Okay. And Mr. Walters, in the prior DEC rate case, the commission rejected the rationale for using, and I'm going to pronounce it, facetious, adjusted betas for the CAPM. Why should the commission give weight to this beta calculation method in the current proceeding?
I appreciate the question. And I think I've provided, plenty of academic literature on that, and why the Vasicek adjusted betas are superior to the value line adjusted betas, which use a method known as the Bloom adjustment. In addition, industry institutions such as Kroll, which is formerly Duff and Phelps, which was formerly Ibbotson and Sons, where the SBBI books, the stocks, bonds, bills, and inflation books, they relied on Vasicek adjusted betas. So while they're not as routinely used in regulatory proceedings, for whatever reasons, I don't know, maybe it's because of limited availability to certain analysts, but there are instances where commissions are relying on them. Recently, I was in a handful of Arizona rate cases, and the most recent one where an order came out was the UNS gas case, and I did employ the Vasicek adjusted betas in that case, and they did accept my recommendation in their consideration, and which also included a reduction in the ROE for mitigating risk factors such as their alternative forms of rate making and a thick equity ratio and superior credit ratings.
Now, Mr. Walters, in the prior DEC rate case, the commission rejected the use of long-term average of value line betas. Why should the commission give weight to this method in this proceeding?
I mean, it's just the use of the long-term average betas just gives you another point of data to use. I mean, it's still a relevant benchmark because betas as published by Value Line are assuming 5 years of historical stock prices and volatility. So to the extent where there were any kind of blow-ups in the data within that 5-year period, you could look at the long-term averages as a meaningful benchmark. And I think at the time, what we were seeing, and I think that was 2023 or 2024, 5 years of data would have assumed that the volatility in stocks from the falling out of, as a result of the pandemic would have been rational going forward, and they weren't. After that 5 years of data has now been priced out of betas, the long-term average beta is more in line with the 5-year beta presently. So, I mean, accepting 5-year beta from Value Line would be relatively consistent with the 10-year beta, I believe, at this time too.
Okay, now, Mr. Walters, in the prior DEC rate case, the commission rejected use of Kroll's recommended equity risk premium for the CAPM. Why should the commission give weight to this forward-looking equity risk premium recommendation in this current proceeding?
A good question. So Kroll is one of the most often cited sources of valuation and market assessment data in these regulated proceedings from rate of return analysts. And they're leading experts in business valuation. So to simply ignore their normalized recommended market risk premium, I think would be a big miss. And again, that recommended market risk premium is also within the range that Dr. Morin has put in his textbook, is known as the empirical range of 5 to 8%. So that recommendation is consistent with that. And I would also note that I don't specifically just rely on that market risk premium. I provide multiple different market risk premium estimates, but that just being one. And I think it's a reasonable estimate because, again, it's from a source that's one of the most often cited sources in rate of return testimony by rate of return analysts in these proceedings.
Now, Mr. Walters, you note in your testimony the S&P 500 is significantly influenced by the Magnificent Seven. Given this influence, why did you decide to perform a constant growth analysis, develop estimates of a market risk premium?
Using a forward, estimating the market expected market return is as imperfect as estimating the cost of equity for anything else. So there's different methods of estimating the return, and it's certainly a reasonable expectation or a reasonable approach in estimating the expected market return, which a market risk premium is derived from. And I would specifically state that when I use the S&P 500, the method that I use is the FERC's established method, where they exclude any of the S&P 500 companies that do not pay dividends, as well as those that have growth rates less than 0 or greater than 20%. So there's some moderation in there as far as reeling in reality, if you will, by excluding those that have very excessive or negative growth rates. And again, estimating the expected market return of the market using a DCF is still a reasonable estimate. But like any other model, it's got its own cautions that you should take into consideration.
Now, Mr. Walters, figure CCW9 on page 87 of your testimony. I'll give you a minute to get there.
I'm there.
It presents a summary of your cost of equity models. Your DCF mean, your DCF median, your CAPM value line beta, and CAPM historical beta, results appear to be in the range of roughly 8.5% to over 11%. How do you then arrive at a recommended range of 9% to 9.9%?
I don't take into consideration any one model result. I would refer you to the immediately preceding page where table CCW8 is presented. And there I've summarized all of my CAPM results using all the market risk premium estimates and all the different beta estimates. And if you take the average of all 12 of those numbers, they're closer to 9.05%, give or take. If you take the average of those results, excluding the lowest result and the highest result, they're about the same. They're under 9.1%. And again, I think the top end of my range is supported by my bond yield plus risk premium analysis, and then the results of my DCF fall within those two boundaries. I mean, there's no precise method, but there's certainly ways where I could point you to how that range was informed at least. And like I said, if you just take the averages of the CAPM results, they're below 9.1. And the risk premium averages around 9.9.
And why would you exclude the high end and the low end?
So, like for example, on table CCW8, you'll see that the highest result is 1199 and the lowest result is 686. It's just a method of seeing how much those outliers really impact the results. And again, even if you left them in, they're still close to the with or without them. The averages are.
Okay. Now, Mr. Walters and Mr. Fahey, last week DEC witness Heath and Kanoy, I guess it is, are okay. I keep hearing different pronunciations
Mr.
for
Coyne?
that name. Yeah. Okay. Argued that NYRPs reduce absolute risk. NYRPs do not reduce relative risk, and thus no downward ROE adjustment due to the presence of an NYRP is required. What is your response to that determination? And do you have further comments on this particular topic?
I think I would start in that NYRPs, at least as we have them in North Carolina, do reduce that relative risk. And that each state is at least somewhat unique. And in my analysis, I've concluded that NYRPs are seen in sort of a minority of states and sort of viewed in context that we represent this gives us a lower risk than that range of utility regulatory jurisdictions.
I would also, in Mr. Fahey's testimony, he identified, I think, 6 other states where they have a similar suite, if you will, of risk mitigators and performance-based rates and multi-year rate plans, partial or full decoupling, and some other factors that he looked at. And many of those states that had the suite of those risk mitigators in total, similar to what is here in North Carolina, many of those states are deregulated and wires only transmission distribution utilities. So that really gives vertically integrated electric utilities in North Carolina advantage to other vertically integrated utilities in other states. And again, even absent the presence of those, as we discussed earlier, Commissioner McKissick, DEC's credit ratings are 3 notches superior to that of the proxy group. They also have a higher equity ratio than the proxy group. So all of that to say that I don't believe there's a credible argument to make that Duke Energy Carolinas is of higher risk, and certainly an ROE in the lower half of my range is warranted.
All right, and as the rebuttal testimony of DEC witnesses Bateman and Farmer change your thoughts or perspective?
I didn't listen to all of witnesses Bates and Farmer.
Well, the rebuttal testimony that's written.
I didn't read
Okay.
Bates or Farmer. I'm sorry.
All right. Well, Mr. Fahey, on pages 21 through 24 of your testimony, you described 6 reasons why decreases in risk associated with a PBR, MYRP, it's not captured in financial models used to determine ROE. Many ROE witnesses use earnings per share growth estimates in their DFC models. Can you elaborate on your statement from page 22, lines 9 through 11, given the use of EPS growth estimates?
So that is part of my second argument. That looks at, says many other factors that have larger influences on ROEs. I'm not in the context of I say ROEs here, I'm referring to approved ROEs by commissions as opposed to referring to specific analyst results. So that's a slightly different comparison. But there are certain factors which, at least in my opinion, influence certain commissions' decisions regarding ROEs. For example, wildfire risks in California might be something that particular commission considers more so than other commissions in other jurisdictions.
Okay, now you note that CAPM model may factor in the relationship to risk and stability of cash flows. Are you suggesting that a CAPM is conducted, then the ROE recommendation does count for the relative differences in the risk associated with a PBR, MYRP in comparison to a proxy group?
What I'm saying is that may be theoretically possible, but I have not seen a complicated statistical analysis that has been able to eke out that particular measurement. You'd have to go through a fairly substantial statistical analysis, a multivariable regression of some type to be able to try and separate out the effect of those things based on a quantification of either different jurisdictions or different earned returns or other factors, and doing that using market data or using regulatory approved ROEs would be very, very complicated, and I'm not sure if the results would be meaningful, but theoretically the analysis could be done.
Now, can you elaborate on your 6-point and provide the difference between your 6-point to your second and third?
So the 6-point references not being able to use the data from the proxy group simply because, again, referencing commission approved ROEs for those operating companies within that proxy group, which is a different metric than Witness, Walters, and Coyne may be looking at when they're looking at market data.
Okay.
And again, it also gets into that how those approved ROEs versus market data is slightly different there.
Thank you. Now, you know, on page 33 of your testimony that RRA raised its ranking of North Carolina following the signing of House Bill 951. Based on your review of similar regulatory mechanisms implemented in other states, did RRA adjust its ranking for those other states following similar regulatory changes?
I believe RA does adjust its rankings for other states depending on the regulatory changes that those other states go through. If you were to look at the graphic that I have on page 32, you would see some of these state names are highlighted, and those are the states in which RA was considering changes at the point that this graphic was produced in March.
And I'll add something here real quick on that point. Whenever Arizona started implementing their formula rate policy, they came out with in December 2024, and started implementing formula rates. RRA took into consideration that, and I believe they have raised their regulatory ranking based on those changes in regulatory policy out there.
Okay, now, Mr. Walters and Fahey, should the MYRP be approved, what is your recommended downward adjustment to ROE in basis points? And what evidence do you have to support this adjustment?
I'll take that one real quick. As an initial matter, there's no specific analysis that I'm aware of that can be performed to precisely estimate or precisely calculate a reduction in the ROE, and that's why I presented as in my testimony an ROE in the lower half of my range. I would note that I believe in the last DEP case, the range of recommendations or at least quantifications of those reductions, including DEP witness Dr. Morin, ranged from 10 to 25 basis points. I would note that anything within 10 to 25 basis points is still keeps the ROE in the lower half of my range, the lower half of my range being 9.0 to the midpoint of 9.45.
Okay, now in the prior DEC rate case, the commission determined that mechanisms to mitigate regulatory lag similar to the NYRP are prevalent in the industry and in that proxy group, and thus concluded no downward adjustment to ROE was appropriate. Why should the commission arrive at a different conclusion in the current case?
So I would believe that that view may have encompassed greater what can be called alternative regulatory mechanisms in the broad industry versus the mechanisms that we have within North Carolina. Because we have MYRPs, we have residential decoupling, which including residential decoupling, PIMS, and earnings sharing mechanism. In addition, we had even more favorable legislation passed last year that gives more recovery through fuel, which includes a faster recovery of various costs to Duke.
And I would, just chime in again and reemphasize the analysis that Mr. Fahey did, where he identified 6 other state level jurisdictions that have a full package of alternative forms of rate making or risk mitigators consistent with or similar to North Carolina. Many of those states being deregulated, meaning they're only transmission distribution electric utilities. I don't recall the 6 other states off the top of my mind, but I recall many of them being in the Northeast. I don't know if you have that. So again, that would show that vertically integrated electric utilities in North Carolina have an advantage relative to other vertically integrated electric utilities throughout the country. And again, I would also point to that could also be taken into consideration given the vast difference in their credit ratings presented on my exhibit CCW2.
Mr. Walters, in his rebuttal testimony, page 29, DEC witness Heath calculates that your recommended ROE and capital structure results in FFO debt below Moody's downgrade threshold and limits DEC's ability to respond to unexpected events. What is your response to this analysis?
I'm not as familiar. Our firm does not have access to Moody's, so I don't have the full suite of Moody's calculations and their estimates. I would note that the financial integrity analysis I did was using the S&P's methodology specific to DEC's North Carolina operations to make sure that my recommendations would support their financial integrity here. And not that I'm recommending anything to lower the company's credit rating. I would note that they are still 3 notches above the proxy group. So if they even were to incur a ratings downgrade, they would still have a 2-notch rating advantage compared to the proxy group. And they would still be an A3, which in no way they would be able to absolutely access capital at reasonable terms and prices at an A2 rating or an A3 rating.
And you've not reviewed Heath's rebuttal testimony, I take it. That's my understanding.
I've reviewed Mr. Heath's testimony.
You have reviewed it?
Yes.
Okay, all right.
Not like within the last several days, but after it was filed.
Okay. Well, in that case, how can the commission be certain that your recommended ROE and capital structure will maintain DEC's credit rating under Moody's methodology?
I didn't do the analysis to do that. I also, as I just explained, I did the financial integrity analysis using S&P's methodology based on our firm's resources, and made the conclusion that my recommendations would support their financial integrity. And again, even if not that I'm recommending anything that DEC be downgraded, I don't think a ratings downgrade, the cost to keep the existing rating would be more expensive than any ratings, one-notch ratings downgrade. Because as we all know, the cost of equity is more expensive than the cost of debt. Plus, it's got to be grossed up for income taxes. So it's just a much more expensive form of capital, whereas they might experience a 5 or 10 basis point increase in the cost of debt that would, ratepayers paying a lower authorized rate of return would be, paying significantly less than what the increase in the cost of debt might be.
Okay, now in DEC witnesses deep rebuttal, he criticizes your S&P credit analysis, arguing that it compares the FFO debt thresholds to an operating company to that of utility holding companies. What is your response to that criticism?
The FFO to debt is an operating company analysis, and S&P applies that FFO to debt metric to both operating companies and holding companies. While my analysis might be imperfect because S&P doesn't necessarily take a look at specifically just jurisdictions, the analysis coming out of the jurisdictions, we're only concerned with the metrics that can be produced by DEC's North Carolina operations in the immediate proceeding. So that's what I look at in this analysis, and based on that, I conclude that my recommendations in this case would support their financial integrity.
Okay, and Mr. Walters, starting on page 71 of your testimony, you describe how you use the Cal structural break test on DEC witnesses coyote RPM methodology. How did you select these particular break years?
There was no specific analysis that isolated break years. I just happened, I looked at just years within the period and measured the slope of the relationship between interest rates and the equity risk premium before and after those break points, and it was statistically significant for all 6 of those break years, meaning that the relationship structurally changed pre and post. And the statistical value that come out of that, the p-values, all of those values are less than 0.000001, meaning there is a 1 in 1 million chance that those relationship values were a fluke. So in other words, it's such a significant and strong relationship that the analysis showed that there's a structural change in interest rates and the equity risk premium relationship before and after those years.
Why did you not select a more recent break year to reflect the Federal Reserve's interest rate increase in 2022 through 23?
I don't have a definitive answer for that. I mean, I can certainly go back and do that as a late filed exhibit if it would please the commission.
If you could do so, that would be appreciated.
Do you want me to look at all of the, I mean, what you're going to have though, I would note that if we chose 2023, you're only going to have, 3 years of data following it. So there's not going to be much of a relationship. I would caution that, but I can certainly do that and present that to the commission if it would.
That would be excellent.
All right, I'll write, give me a second.
These, as I say, these are questions from our commission staff.
Sure.
And very nuanced, very detailed. So perhaps that late file exhibit may provide clear context in terms of response. What are the results of these Cal structural break tests on your recommended risk premium analysis?
They have no influence on my risk premium analysis. They just emphasize the point that the relationship between interest rates and the equity risk premium have changed. As I stated earlier, historically, that slope, if you will, the relationship indicated that for every 100 basis points change in interest rates, there was an inverse approximately 40 or 50 basis point change in the equity risk premium. And currently, I can give you an exact number if you give me a moment. Currently, that slope has gone up to about 86 basis points per 100 basis point change. So the equity risk premium is more responsive to changes, which does not necessarily mean the ROE is as responsive, right? So if the ROE stays flat while the interest rates change, the equity risk premium, the difference between the two is what changes the most. So even if the ROE stays flat, right? So that's the relationship that this is capturing.
Thank you. Now, Mr. Fahey, on page 16, now wait till you get to your testimony.
I'm there.
Okay, lines 10 through 12 of your testimony, you state from October 1 of 23 through March 31 of 26, approximately 31.11% of DEC's total revenue for North and South Carolina flowed through a rider. Can you provide the breakdown by year and jurisdiction?
I believe that statistic comes from a public staff data request response, just data request 197. I'm not sure exactly which number. And so I don't have that in front of me. I believe we could probably provide that as a late filed exhibit.
If you
it's
could
not
provide
already-
as a late file exhibit, it sounds like it deals with the data request, so it should be pretty straightforward and not particularly cumbersome to provide.
Yeah.
Thank you. Now, Mr. Fahey, on page 34, lines 10 through 17 of your testimony, you note that investor sentiment scores for the earnings call on November of 2021, where House Bill 951 was discussed, were higher than for recent earnings calls. Now, what were the actual scores for the November 2021 earnings call and the other earnings calls that were analyzed?
I believe I have that information within my work papers. Again, we would have to do a late filed exhibit.
If you could provide that in a late file exhibit, it would be appreciated.
I would also, I believe that is within my work papers. I would need to double check. If not, I can dig through S&P and get that information for you.
Okay. And one quick follow-up here. What were the investor sentiment scores for earnings calls on the other NYRP PBR regulatory mechanisms you describe in your testimony?
So the way the investor sentiment scores are calculated, it is based on that investor presentation and those questions that investors ask. And so they don't necessarily identify each specific piece of the MYRP. It's sort of an overall score for that particular meeting and presentation and questions. So I'm afraid I don't think that data exists.
Okay. Now, Mr. Fahey, on pages 37 through 38 of your testimony, I'll wait for you to get there.
I'm there.
You state that from an investor perspective, DEC has earned its authorized ROE. Can you elaborate on that point and respond to DEC witness Jacob's testimony that DEC has under-earned its authorized ROE?
So it gets into exactly how you calculate an ROE. Depends on what adjustments are made or not made, and sort of who is, whether that's presented to this commission or within the regulatory structure, or there's various things you may change. And there's also differences between measuring what an earned ROE from a historic basis and determining a cost of capital going forward. So one is a forward-looking estimate and another is a factual accounting-based data. So the way I calculated this particular one was using an annual earnings release. This is information that Duke Energy provides to its investors. You can find it on their website. A similar metric of calculating it I have as a footnote would be using their 10K form. There's some slight differences between the two, but they are similar. And in my opinion, from an investor of Duke Energy, this is the format in which they would be looking at an ROE. And these are Duke Energy's reports, but the numbers here are for DEC. because they are a large enough subsidiary of the parent company that that information is provided within the reports.
Thank you. And Mr. Fahey, in their rebuttal, DEC witnesses Bateman and Farmer disagree with your recommendation to include large loads in customer growth adjustments for the NYRP rate years. What is your response to their rebuttal testimony on this topic?
I believe that that load should be included because it is based on known and measurable contracts.
Right. Now, Mr. Walters, on May 18th, 2026, Dominion and NextEra announced a merger. How would that merger announcement have impacted the results of your individual ROE methodologies and overall recommendations?
I mean, they would certainly be removed from my proxy group going forward. So I guess just depending on the model, I mean, they could certainly have a minor impact. For example, on the constant growth model, you know, I mean, Dominion's result of 11.19 is consistent with the median of the whole proxy group, whereas NextEra Energy's constant growth DCF result of 10.43 was slightly below. Just a second here. Dominion has an above average beta on at least 2 of the 4 measures I used, and I'm sorry, 1, 2. On 3 of the 4 betas I measured, Dominion has a higher beta, so removing them would produce a lower ROE. And NextEra has a higher beta than the average on all 4 measures, so removing both of them would have a reduction in the CAPM. I don't know that it's significant enough to make an adjustment to my ROE results or recommendations. But I would leave it with that, because like I said, they have a consistent with or lower than average DCF result, but removing them from the CAPM would lower the CAPM results for the proxy group. So they might be a wash using the data as
Right.
presented here.
Got it. Thank you. Those are kind of cover all of the questions from our commission staff. Let me see if any other commissioners have questions. Okay. It looks like Commissioner Vandervoort. After this, we'll take our break.
I got one technical question and one sort of broad question. And these guys aren't coming back after rebuttal.
No.
Because it's a little bit weird talking to you in the context of what we know Duke said later, but let me ask you a quick technical question. As far as I can tell, you did the Chow test for bifurcated data, but you then ran a weighted least squares rather than simply bifurcating the data and using a regular least squares model on the end that you think is most relevant. Is that right?
So the Chow analysis just is a way to confirm that there's been a change in the relationship.
Right. Now, how you respond to that, you can either take this weighted least squares, or you can simply say, hey, Chow told me that the fundamental relationship between these parameters has changed, and he tells you when, where, and you can just you can bifurcate the data and run the least square. I mean, I'm just asking why you didn't do it. I'm not saying it's better.
Yeah, so are you asking why I just didn't do an analysis on the data thereafter and
Yes.
exclude?
Yeah.
Okay, so the way that the weighting methodology works in weighted least squares regression, it exponentially decays the weight applied to longer dated periods.
Right.
I don't think that you should just eliminate the relationship from those periods altogether. Because they certainly inform commission decisions as they go along, but the relationship is, it's, by the time you get to the 1980s, it's so decayed that there's very minimal weight applied. to it.
Okay, I guess I'm just saying, Chow tells you that it's statistically defendable to recognize that the two sets of data are subject to two different relationships. Anyway, that's just.
Yeah,
just-
and I would just clarify real quick, Commissioner, that the weighted least squares slope or the relationship is pretty consistent with the post slope
Okay,
or the post period slope.
so you're just saying you're not going to get a fundamentally different answer if you.
I wouldn't
use
expect it
the
to.
bifurcated least squares. I get it. So on a more broader, I'm a little unclear with the answers that you gave to Presiding Commissioner McKissick's questions. This proxy thing comes up all the time. And I'm just trying to understand what your answer is. Is the fact that some folks, I guess the commission last time, and we're not subject to stare decisis by any stretch, but the argument was, the proxy universe contained a bunch of utilities that had similarly advantageous regulatory structures to Duke, and therefore it was an accurate proxy. And your argument, if I'm not mistaken, is no, if you look deeply into those proxy companies, either they have advantageous regulatory structure similar to North Carolina, but it's only for T&D regulated utilities. So, it doesn't compare with a vertically integrated utility, or know that some of them don't have those kinds of advantages, especially considering the latest legislation. Is that roughly where we're going, or can you clarify that?
Yeah, I appreciate the question, Commissioner. The proxy group that I used, I start with DC Witness Coins proxy group and reviewed it for any additional factors that may have happened after he filed his testimony, such as merger and acquisition announcements, dividend restrictions, ratings downgrade, whatever the case may be, that would then not make them useful in the proxy group. And then I did my assessment based on that. And I would refer you to my exhibit CCW2, where I take a look at their credit ratings relative to the proxy group. And it's undeniable that DEC has superior credit ratings to the proxy group. And that may be in part due to what Mr. Fahey was pointing out in his analysis. But what I'm saying, when I referred to his analysis, where he identified 6 other state level regulatory jurisdictions that allow for a suite of risk mitigators that's available to or similar to what's available here in North Carolina. Many of those states or state level jurisdictions are deregulated wires only companies, which would then mean Duke undeniably has an advantage relative to other vertically integrated states, because they're not other states that have vertically integrated electric utilities do not have necessarily the same kind of suite of risk mitigators that are available here.
Okay, so I think that's getting to the point I was making. So you're looking at the proxy group, and Mr. Fahey, kick in if you want. I'm just trying to understand what you're saying. Some of the companies in the proxy group, because of mergers, acquisitions, they're gone. That's clear. But then the rest, I think there's a tension here between what the commission has said maybe in the past and what I'm hearing, which is, in the past I heard that a lot of these companies that are in this proxy group have similarly advantageous regulatory structures like North Carolina. But what I'm hearing is yeah, they may have something, but if you take the T&D regulated entities out, Duke stands pretty much alone with the MYRP, and all the advantages that we have and therefore, and the manifestation of that is the credit rating.
I can't say definitively, but there's certainly reason to believe that might be the case.
Mr. Fahey, can you?
So I would add that in my analysis, I don't distinctly view the proxy group. I'm looking at different regulatory jurisdictions. So any sort of comparisons within the proxy group, I leave to witness Walters.
So, I mean, it would be really relevant to us if somebody could say, here's a proxy group of vertically regulated utilities that operate with very similar, in a very similarly advantageous regulatory context. And let's use that as our proxy group. And here's what the ROE. I mean, that hasn't been said, or has that been said?
I don't believe it's been said.
Thank you. I mean, I'm sorry. I just thought I missed something, but
Yeah, again, I think you'd be hard pressed to find vertically a comparable proxy group that has a similar suite of risk mitigators of vertically integrated electric utilities.
that's what I think. That's
it'd be-
what I think. And you're saying as not as maybe as a cause and effect question, but at least one manifestation of that is Duke's very high rating.
Yeah.
So it's not inconsistent with what we're
Right.
saying. All right. Thank you very much.
Okay,
Chairman McKissick, before we break, if I could.
sure.
It has been my experience that the commission does ask public staff witnesses about rebuttal testimony from utilities. And I think in fact, some of the commission questions that you asked were on DEC's rebuttal. And I heard Commissioner Vandervart maybe say he was unclear whether he could discuss Duke's rebuttal, the DEC's rebuttal testimony. And I thought maybe the presiding commissioner could discuss that point.
Sure. I mean, typically we get in rebuttal on rebuttal. I think the extent to which you all have read rebuttal testimony, can respond to questions that have been offered, that would be excellent. To the extent you have such knowledge and are prepared to do so at this time, to the extent you may not have full and complete knowledge, then we would not expect you to get into responding to those questions.
Thank you, presiding commissioner.
So you're saying we can ask him a question about Duke's rebuttal?
To the extent they do have knowledge, and they will not be coming back.
Right, that's the question I had. And I've got one question really.
Why don't we go ahead and take our break?
Sure.
We're past time for taking that break. It's now 11:17. We will reconvene at 11:27. Started? Yeah. All right, well, we can continue with commissioner questions. I believe Commissioner Vandervaart might have one or two additional questions.
Yeah, I mean, so now you're familiar, I'll ask you, are you familiar with the July, the recent rebuttal testimony filed by, I think, witness Bowman, where they revised, where Duke is proposing a much lower, well, they're deferring some costs, but they've dropped their ROE request. Are you familiar with that?
I'm familiar with the ROE request change, but I'm not familiar with Bowman's testimony.
Okay, but I guess since ROE is your bailiwick anyway, that's or at least one of them. I guess my only question to you is from my standpoint, all I can look at that as saying was, well, you know, Walters must have been at least somewhat right, because the original request made by Duke was 10.98 or something as being compliant with Hope and Bluefield. And now all of a sudden, Hope and Bluefield, I asked witness Bowman, and she assured me that Duke wasn't going to submit something that wasn't compliant with Hope and Bluefield, which that's rational. So apparently now that's changed. So I guess my question to you is, what are your thoughts about, and let's just keep it to ROE. But so what are your thoughts about the fact that that got changed? Does that support your thinking, or doesn't, whatever?
Well, I appreciate them lowering their request. I think that it's still excessive. It's above the range indicated by my market models that I believe support the Hope and Bluefield standards, or in line with the Hope and Bluefield standards.
Okay, Mr. Fahey, any other?
I agree with Mr. Walters.
Okay, thanks very much.
Thank you. We will now move on questions on commissioner questions. Let's see who's in the queue. Attorney General.
Rita Coxton on behalf of the Attorney General's Office. I have just a couple of questions in follow-up. Commissioner McKissick's question regarding the Dominion Nexera merger. Do you recall those?
I do.
Did you remove those from the proxy group in your recently filed DEP testimony?
I don't recall the date the data was pulled in my analysis. If the data was pulled after the announcement, I would have. But as I say today, I don't recall if they were or were not in my DEP testimony.
Would you accept subject to check that they were?
I would.
Nothing further.
All right, Sickler. None.
No questions. Thank you.
Why don't I get see, are there any interveners who have questions? If so, come up to the center seat, please.
Thank you, Presiding Commissioner McKissick, David Neal for NCJC et al. Like musical chairs, as usual. So, Mr. Walters, you had a question from Presiding Commissioner McKissick related to what I believe is pronounced the Vazicek adjustment in the betas. Do you recall that?
I do.
And to take a step back, you would agree that the purpose of beta is to approximate a company's risk.
Specifically their market risk, yeah.
And when it comes to this exercise of attempting to estimate the cost of equity, would you agree that what's most important is the sector that the company is in when it comes to risk?
Yeah, so if I understand your question, I would answer it this way. The Bloom adjustment that Value Line incorporates in their beta is regardless of industry. It's just a standardized one size fits all adjustment that's applied to all of their betas, regardless of sector or risk. And it's just their way of goes back to the notion that securities have a tendency to revert towards the market beta of 1. There's been empirical studies show that utility betas do not do that, which would support the use of VASA check adjusted betas, because the VASA check adjustment gives consideration to accuracy in what the beta is historically done. And it applies it to a proxy group, if you will, or an industry sector, as opposed to the market at large.
Thank you. You did understand the question. That's, I had another question about Presiding Commissioner McKissick's questions to you about your use of the sustainable growth and multi-stage DCF models. Do you recall?
I do.
And is it your understanding that even FERC has adopted at least a 2-stage DCF model that uses GDP as the long-term growth rate?
There's
Commissioner McKissick, if I might. I don't know if there's such a thing as friendly questions on commissioner questions like there is friendly cross. But yesterday, Mr. Burns, I think very appropriately said, I know that my client is aligned with the public staff's large load panel, but I have questions in where we differ. If Mr. Neal could articulate where his question, particularly this one and frankly the preceding one, results from a difference of opinion between his client, his ROE expert, and Mr. Walters, I think it would be an appropriate question. I don't think he can articulate that difference.
If I may be heard.
Yes.
I've always understood that the function of questions on commission questions is to help clarify the record, make sure that a point that was raised from the commission is fully explained. And if there was some nuance or particular issue that was lost, or that the commission would benefit from further elaboration. I don't recall this issue coming up as friendly cross being objectionable on questions on commission questions. It seems like the wrong category.
And Your Honor, if I could be heard, only because I anticipate that council would likely lodge a similar objection when I ask my questions on commissioner questions for similar reasons to those raised by Mr. Neal. This is a public body whose goal is to determine what's in the public interest, to balance the interest between the utility and ratepayers. And to object to clarifying questions on commissioner questions because it's quote friendly, I think really undermines the whole purpose for which this body is seated and the reason for which you're called to make a decision. So I would ask that in the interest of justice and for a full record upon which you make this decision, that questions that merely seek to clarify and build upon questions asked by those of you on the dais be permitted.
I think when it comes to questions on commissioner questions, commission questions, it's appropriate to ask clarifying questions that need to be clarified and which will provide the record in this proceeding with as much clarity to the public as possible to do so. So the extent to which it is an objection that has been raised, because it wasn't phrased as an objection per se, I will go ahead and overrule that at this time. Mr. Neal, you can go ahead and proceed. We want the record full and complete, but just be aware that we want to move things along too.
Absolutely.
And we don't need to do things that are already clear, that are consistent with what other testimony might have been in the case.
Appreciate that, and we'll certainly move quickly. You also had a question regarding the use of the risk premium method using information from Kroll. Do you recall that?
I'm sorry, Mr. Neal. I don't know that we ever got to answer the question about GDP.
Thank you. I appreciate that. So yes, that question was, you're aware that FERC has adopted a 2-stage DCF that uses GDP as the long-term growth rate.
I'm aware of multiple jurisdictions that use at least some form of the multi-stage model, including GDP. And FERC is one of them. I know Illinois explicitly requires the use of it in their analyses lately. And again, Arizona has recently incorporated it whenever it incorporated my recommendations in their determination.
And one concern with using analysts' short-term growth rate expectations in the DCF model is that, especially in a period where there's a booming market, that may give an inaccurate result, correct?
Yeah, again, these no analyst publishes quote unquote long-term growth rate estimates. They're always short-term, whether it's quarterly and at most 3 to 5 years. So, and as I explained earlier to the commissioner, that the model assumes perpetuity. And if you incorporate a growth rate that's expected for 3 to 5 years in perpetuity, I've demonstrated this before. If you assume those kind of growth rates, they will overcome the entire GDP, which just is nonsense, right? So it can't happen.
Okay, and I think this is the last topic that I was moving to a moment ago. There was a question about your use of Kroll's risk premium in
The market risk premium like
Yeah.
CAPM, yes, I remember that.
And you would agree that Kroll is widely used by investors, is widely used by the financial community.
Yeah, they're, as I explained earlier, that's their leading resource in business valuation. They're one of the most often cited sources for data in rate of return analysts, such as myself or Mr. Coyne, or any other ROE witness in regulatory proceedings. They're widely used, widely cited, and an authoritative source in the field.
No further questions.
Thank you. Any other intervener that has questions on commissioner questions at this time? Walmart, come on up to that center seat. It's always easier for people to see you up there. They don't have to bend their necks too far.
Good morning, gentlemen. Carrie Grunman on behalf of Walmart. I'm going to jump around a little bit, so I apologize. Just out of curiosity, did you review the direct testimony of Walmart witness Steve Criss?
Yes.
And do you recall that as exhibits to his testimony, he produced information about prior ROEs awarded by other jurisdictions around the country?
Yeah, that's often his testimony.
And let me stop myself because I have not first identified the commissioner question upon which I'm asking these questions. So Commissioner Vandervaart specifically went through with you and asked you questions about the company's voluntary decision to reduce its ROE to 10.48%, and then asked you specifically whether that reduction created any issues under the Hope and Bluefield standards. You recall that?
I do.
Okay. So then going back to my questions about Mr. Criss's testimony, do you recall that some of the data that he produced is a listing by date, by utility, by jurisdiction, not only the ROE requested by the utility, but the ROE ultimately approved by that commission?
That, if memory serves, yeah, I believe that's to be true.
And is it common in your experience, Mr. Walters, that the ROE approved by commissions around the country is often lower than the ROE requested by the company?
I don't know that I've ever seen an example where they were actually authorized what they requested.
And in your experience, how often do you find that a utility appeals that decision or somehow claims that lower ROE authorized by the commission violates the Hope and Bluefield standards?
I cannot think of too many instances where utilities have appealed the ROE, at least successfully.
And then turning subjects, Presiding Commissioner McKissick asked both of you or discussed with you the concept that in the prior MYRP, the commission declined to impose a downward adjustment for the risk reducing nature of the MYRP. Do you recall that question?
Yes.
Yes.
And then you all were asked, as you may recall, why the commission should take a different approach this time. Do you recall that?
Yes.
And do you agree with me that the first MYRP was just that? The first MYRP, it was the first chance North Carolina ever had to implement the legislation authorizing a multi-year rate plan.
Yes, it was the first MYRP under PBR.
And now in this case, one of the things that's different is we have the actual experience of what occurred over the course of the first MYRP.
In rate years 1 and 2, yes. Rate year 3 is ongoing.
And so the commission now has actual facts about experience in the MYRP to determine whether or not the MYRP in fact reduced the company's risk. Do you agree?
I would agree.
And then a couple of other things I'd like to ask if that I don't think you mentioned, but I'd like to know your thoughts on. You had some testimony from your colleague Jeff Thomas with respect to the fact that there was a mismatch in the prior MYRP where the company was entitled to put in certain projects.
Commissioner McKissick, I'm not quite sure what commission question this one relates to.
If you
Mr.
could
Mehta?
identify the one that it relates to.
I am still following up on the commission's questions about why the commission could make a different decision to issue a downward adjustment on the MYRP, which differs from its decision in the prior case. I am continuing to ask follow-up questions with respect to that, Commissioner.
And we did have questions that were directly related to that issue. So you may proceed.
So returning to that, Mr. Thomas indicated that there were numerous projects, MYRP projects, that the company was allowed to put into rate base, but that did not ultimately go into service on the date they were projected. Do you recall that?
That is my understanding of his testimony, yes.
And as a result of that, the company earned monies that it was able to retain and potentially use to increase its earnings. Do you agree?
I agree. I believe there's the potential for it to increase its earnings, and there's the potential for it to then spend monies on other projects.
And in this line, but also following up on another commissioner question, Commissioner McKissick specifically asked you about your response to company witness Bateman's rebuttal on your proposal and need for a customer growth adjustment and large load customer adjustment, correct?
Correct.
In the event that the commission does not adopt your recommendation to update load growth for known and measurable contract changes, what will happen if the company's load grows during the MYRP2 period with respect to its earnings?
So the way the customer growth adjustment works is we look at the expected number of customers sort of going forward. And if we, for example, did not take into consideration those known and measurable contracts with a large amount of sales behind them, then those sales would not be reflected within the rate setting mechanism. And so would allow Duke theoretically an over recovery because they would be setting rates to recover a revenue requirement. And then they would be selling more than they expected to recover that revenue requirement at that rates set within this proceeding. So as a result, you would end up with greater earnings.
And so in that case, if the commission does not update its load forecast to account for known and measurable customer changes, the company will in fact have lower risk.
I think that in terms of risk, I'm not 100% sure. In terms of there are likely higher chances to have greater earnings, and the sort of follow-on relationship of greater earnings resulting in an investor benefit, then yes.
And then I think my final question, Mr. Walters, you were asked about whether you had done any calculations by the commission on whether your ROE recommendations would have an impact on the company's FFO to debt ratio. Do you recall those questions from the commission?
I did.
And I just want to be clear, you did not do those calculations.
Not Moody's. I did an S&P.
Okay.
And that is presented in my testimony.
But have you seen the testimony from some other intervener witnesses that indicate that one of the things the commission should take into consideration is the basis point difference that would accrue from a one-notch downgrade versus the basis point difference that would accrue from a lower ROE?
I can't specifically recall the witness, but that is often discussed in many rate cases.
And so do you think in this case, the commission should take into consideration the totality of those sort of, it feels like they're toggling impacts, that the commission should take those into consideration?
Yeah, and I think I provided some guidance or some response to the commissioner on that, where I stated, if the company were to receive a ratings downgrade from Moody's, they might experience, say, a 5, 10, 15 basis point increase in their cost of debt. But the cost of equity at a higher equity ratio to more than prevent that ratings downgrade will cost ratepayers so much more money than the incremental increase in cost of debt.
And from a comparison to the proxy group, I think you still believe that DEC would continue to be less risky relative to the proxy group, even with a one-notch downgrade.
Oh, yes. So like I mentioned, they have a three-notch rating advantage relative to the proxy group as it stands today for Moody's. So if they were to experience a one-notch ratings downgrade, which again, I'm not advocating for, and I don't think my results would do such a thing, they would still have an A3 rating, which would be 2 notches above that of the proxy group.
Thank you. Those are all the questions I have.
Thank you. DEC,
No questions.
public staff.
Thank you, Presiding Commissioner McKissick. Do you have the public staff? I know we moved the notebooks to give you space. Do you have the public staff exhibits at hand?
No.
Is that on the table or is it over there?
It didn't.
We're not sure.
Okay, I was gonna direct, you were asked a question about the riders and the percentage in your testimony. Do you recall that, Mr. Fahey?
Yes, I do.
And what I'd like to do is direct your attention to public staff potential cross-examination exhibit 75 and see if that helps you answer the question. If Ms. Harrod can approach, Presiding Commissioner.
You may approach.
So this is the public staff data request number 19747, which is where that particular metric comes from within my testimony. And it identifies the total revenues associated with the bulk power marketing, cap car riders, competitive procurement, renewable energy rider, decoupling, economic development, energy efficiency, regulatory asset liability, fuel clauses, jobs retention rider, NCEDIT, nuclear tax credits, renewable energy portfolio standards, and state excess deferred income tax.
If you could speak a little louder, I'm sure that the court reporter will appreciate it.
I need to run through that. Okay.
If you could restate what you said, I don't think, it was hard for me to hear, and I
Hold it.
think she had difficulty as well.
Pull it right close to you.
So the total revenues within this exhibit follow the range of DEC riders, including bulk power marketing, the cap car riders, the competitive procurement of renewable energy, decoupling, economic development, energy efficiency, regulatory asset and liability, fuel clauses, jobs retention rider, and the NCEDIT, nuclear tax credits, renewable energy portfolio standards, and state excess deferred income tax.
Presiding Commissioner McKissick, we would like to apply for the record of world's fastest late filed exhibit. And I would also propose to mark this as public staff public staff redirect, public staff Walters and Fahey direct exhibit 1.
Without objection, it's been duly marked and identified. Without objection, it's admitted.
Thank you.
Mhm.
Another topic that you were asked about, Mr. Walters, was that chart on page 29 of Mr. Heath's. Presiding Commissioner McKissick, may we approach?
Sure.
I wanted to put it right in front of you, and I know you looked at it on my computer during the break, but I wanted to get a hard copy to you as well. And the question was along the lines of,
Thank you.
What are your, I've kind of forgotten a little bit of the commission's questions, but I know they directed you to page 29, and if you could please speak to the, what that information is.
Sure. So page 29, specifically table 3, Mr. Heath in his rebuttal presented what he calculates to be the funds from operations to debt metrics at the company's recommendations or requests in this case relative to that of the other rate of return witnesses in this case. And then he presents that as a difference to Duke Energy's actual, as well as relative to what has been cited as the downgrade threshold by Moody's of 21%, I believe.
What does he calculate the downgrade? What does he calculate that your numbers will do versus what the threshold is?
So the downgrade, the quote unquote downgrade threshold that Moody's has identified as 21%. He has calculated on a total Duke Energy Carolinas basis, not just North Carolina, to have a FFO to debt metric of 20.9%. So 0.1% lower than the quote unquote downgrade threshold of 21%.
Are you familiar enough with Moody's to know what a 0.1% would do?
Yeah, so they don't take just a 10 basis point difference from their downgrade threshold on a single instance as a reason to downgrade a company. They've got to be shown to be consistently well below or consistently below the downgrade threshold. And again, even if they are below it, that does not necessarily mean they're going to be downgraded, because financial metrics are only a component of their methodology. They would take into consideration other factors such as the alternative forms of rate making available to them and their other operations. And again, what I presented in my testimony was, we're only as we sit here today, we are only concerned with North Carolina's operations. So I don't think it's this commission's job to worry about what metrics are coming out of South Carolina. And that's why I presented on a jurisdictional basis in my testimony.
Thank you. There were several questions from Presiding Commissioner McKissick and Commissioner Vanderbart about what I think of as sort of baked in concept. Mr. Fahey, you had some specific numbers, and I wanted to draw your attention to page 15 and 16 of your direct testimony, which might illuminate that question a bit more.
Yes, I'm there.
Can you look at that? And also you might want to tie it to your figure 2.2. Again, these are like specific numbers. Can you please respond to the commission's questions in light of those pages in that figure?
Yep. So the specific numbers that I reference on page 15 are what RRA considers the percentage of rate cases that were filed as a multi-year rate case. And those are approximately 12% in 2025. 2024 was 16%, and 2023 was 13.5% of the total number of rate cases, which were a bit over 100 in each year that RRA has been following. And then exhibit, I believe, and then figure 2.2. Oh, once I find it, I want to make sure that is the PBR status across the United States of various states. And this was an analysis that was done by the Christensen Associates for the Maine PUC, and it identified 13 jurisdictions which have implemented PBR. And my understanding is that that review was across the United States in general, and it followed very similar metrics to a previous NARUC assessment, which did not necessarily include every single state.
Okay. Two more topics. Presiding Commissioner McKissick asked you about the known and measurable revenues from signed agreements with large load customers. Did you ask Duke to address some issues around that in your testimony? Did you ask Duke to address those in rebuttal? And can you tell us what was the result?
Yes, in my testimony, I did make one of my recommendations was for Duke to address how to handle this in rebuttal and potentially make revisions to my analysis that I had done. And I do not believe Duke provided any additional analysis within their rebuttal.
Okay, and the final question, I don't know if I want to take judicial notice, but maybe I'll ask Mr. Fahey and seek the wisdom of the commission. DEC's first annual PBR rider was docket number E7 sub 1326. That's where the earnings sharing mechanism would be measured.
Yes,
And the public staff calculated its ROE, calculated the ROE at 10.41. DEC calculated at 9.79. Is that your memory?
and that is my memory, yes.
Okay, second annual PBR rider, the order came out last month, was docket number E7 sub 1350. DEC calculated 9.93%. Under the public staff's method, the ROE would be 10.40%. Is that correct?
That is correct, and that is the sort of difference between calculating that as of end of period and over a 13-month average.
Thank you very much, panelists. I don't have any more questions. Thank you, commissioners.
All right, thank you. Well, we appreciate you being here this morning and providing us with testimony for our consideration as this proceeding moves forward. I don't think, I guess you guys are released at this time. So we appreciate you.
Thank you, Commissioner.
Duke can call their, excuse me, public staff can call their next panel.
Thank you very much. One moment while we.
Sure. Go right ahead. Take your time to logistically move around and get the right parties in the right seats.
Yeah, the public staff would call the distribution panel, which is Jeff Thomas and Tommy Williamson Jr. and Evan Lawrence, who are going to be appearing jointly to address transmission and distribution issues.
Right. In an abundance of cautiousness, we're going to go ahead and swear you in again. I'm not sure all of you have been here before. I know at least two of you have been. You put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Take your time.
Thank you for your patience, Presiding Commissioner. All right, so as I said, for efficiency, we're presenting the distribution panel together with Evan Lawrence. And so let me say, have you sworn the panel? I'm sorry. Okay. Okay. Mr. Thomas, would you please state your name, business address, and current position for the record?
Yes, my name is Jeff Thomas. My business address is 430 North Salisbury in Raleigh. And I am the manager of the operations section of the energy division of the public staff.
Okay, Mr. Williamson, would you please state your name, business address, and current position for the record?
Yes, I'm Tommy Williamson Jr. My address is 430 North Salisbury Street here in Raleigh, North Carolina, and I'm an engineer with the Public Staff Energy Division.
Okay, and Mr. Lawrence, would you please state your name, business address, and current position for the record?
My name is Evan Lawrence. I'm a business address is 430 North Salisbury Street, Raleigh, North Carolina, and I am an engineer with the Public Staff's Energy Division.
Okay. Mr. Thomas and Mr. Williamson, on May 29th, 2026, did you both prepare and cause to be pre-filed direct joint testimony in this docket consisting of 113 pages, 7 exhibits, and 2 appendices?
Yes.
Yes.
And did your testimony contain confidential information?
Yes.
Yes, it did.
Okay. On June 18th, 2026, did you both prepare and cause to be pre-filed an errata and corrections to your pre-filed joint direct testimony?
Yes.
Yes.
Now, did that involve any correction to your exhibits?
No.
Okay. Do you have any additional corrections to your pre-filed joint direct testimony?
No.
No.
If I were to ask you the same questions in your corrected pre-filed joint direct testimony today while appearing on the witness stand, would your answers be the same?
Yes.
Yes.
And did you both prepare and cause to be pre-filed on July 6, 2026, a summary of your joint testimony and docket number E7 sub 1329A?
Yes.
Yes.
All right. And let me then turn to Mr. Lawrence, please. On May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 50 pages, 3 exhibits, and 1 appendix?
Yes.
And did your testimony contain confidential information?
Yes, it did.
On June 18th, 2026, did you prepare and cause to be pre-filed an errata and corrections to your pre-filed direct testimony?
Yes.
And did you file any corrections to your exhibits?
No, I did not.
Okay. Do you have any additional corrections to your pre-filed direct joint testimony, or sorry, your pre-filed direct testimony?
No.
Okay. If I were to ask you the same questions in your corrected pre-filed direct testimony today while appearing on the witness stand, would your answers be the same?
Yes.
And did you prepare and cause to be pre-filed on July 6th, 2026, a summary of your testimony in docket number E7 1329A?
Yes.
Okay. And now I'd like to address all three of you. Have you each reviewed the agreement and stipulation of partial settlement between DEC and the public staff filed in this docket on July 2nd, 2026?
Yes. Yes.
Yes.
And do you support the July 2nd stipulation?
Yes.
Yes. So support the stipulation as a negotiated compromise reflecting give and take between the public staff and DEC.
Okay. All right. So presiding Commissioner McKissick, at this time, I would like to move that the following testimony be entered into the record as if given orally from the stand, and that the following exhibits be entered into evidence as pre-marked. So this is going to be the pre-filed joint testimony of Mr. Thomas and Mr. Williamson as corrected, consisting of 113 pages, 7 exhibits as originally filed, and 2 appendices. The pre-filed summary of joint testimony of Mr. Thomas and Mr. Williamson. The pre-filed testimony of Mr. Lawrence as corrected, consisting of 50 pages, 3 exhibits as originally filed, and 1 appendix, and the pre-filed summary of testimony of Mr. Lawrence.
Without objection, your motion is allowed.
And if you will permit me, Chairman Brawley, you pointed out, made a good point in the prior panel. So that if you were trying to follow along, you would really need the original testimony and the corrected, because the exhibits are as originally filed and then the testimony in both cases was corrected. So you would need both pieces if you wanted the complete package. Okay, so with that said, Presiding Commissioner McKissick, this panel is available for cross-examination and commission questions.
Sigfer is first in the queue.
Thank you. Good afternoon, panel. Mr. Williamson, I'd like to start with you. You testified on page 8 that 2015 marked the beginning of a significant increase in per customer distribution plant investments. Is that correct?
You said page 8.
Yes, sir.
Oh, wow. No. Yes, that is correct.
And in 2017, Duke announced its proposed Power Forward capital spending plan, correct?
That's correct.
Can you tell us about Power Forward?
Yes. So, and one thing I would like to start is that, you know, this case is looking to recover expenses from the PBR1 period, but I extended our analysis to 2015. And part of that was to council's question. In 2017, the company proposed in their rate case, it was the sub 1146 rate case, Power Forward Carolinas. And our exhibit 1, actually, if you would turn there. Our exhibit number 1 for distribution panel is the Power Forward Carolinas executive technical overview. It's dated November of 2017. And this is a summary that the company provided at the time. This was their plan for grid optimization, grid improvement. It was called Power Forward Carolinas in that case. And actually on pages 8 and 9 of that exhibit, there are a list of the strategic programs that the company included in that rate case. And you can go, and they're listed in the amount of spend. So the first one was targeted underground, and it goes down. You see distribution hardening and resiliency, transmission improvements, self-optimized grid, advanced metering infrastructure, communication network upgrades, and advanced enterprise systems. With the exception of targeted underground, which that was the centerpiece in the 2017 case. It was extensly de-emphasized going forward. I think there were some structural issues with obtaining easements and actually getting customer buy-in to replace lines that were overhead and put them underground. But all the other programs there in the list continue to this day. So there was spending that was included in the 2017 case, the 2019 case, PBR1, and now we're seeing these same programs in PBR2. And so that's a summary of of where we are today. And again, I'd say the reason I started with 2015 was the spending that we're seeing today didn't start today. It began in 2015. And actually, let me point you to one more figure. If you'll go to figure 13, my testimony on page 37, starting in 2015 up through 2025, you can see, and this is inflation adjusted distribution capital placed in service. There's a pretty consistent increase year over year. Obviously, we see the 2020 and 2021 downturns due to COVID. And then in 2022, we see basically a return to the trend of spend that began in 2015. And then also on this figure, the 2015 through 2025 are actuals. And then through Discovery, the company provided their projections for distribution capital, and that's actually for 2026 through 2030. That's in the red line for those years. So we see, and I did not include a trend line, but if you drew a line from that is pretty consistent with what's on figure 12, that line is pretty consistent all the way through to 2030.
Mr. Thomas, I thought I saw you approach the mic. Is there anything you wanted to add?
Yeah, I guess the one thing I wanted to add, 'cause I spent some time reviewing Duke's grid improvement plan in the last rate case. And, I think whether it's Power Forward in 2017 or the grid improvement plan in 2019 or 2020 about, and then, now we're in the MYRP zone. I think it really does reflect this kind of just first of all, a need to make investments in the distribution grid to kind of replace some assets and upgrade others. But it also reflects, I think, some of the public staff's overall concern with the pace of the build out, both projects within the MRP and those that are not in the MRP. And so we believe the settlement that reflects some reductions in that pace and scope is good for ratepayers, because we're not standing here today saying there's no need to invest in the distribution system. We are just concerned about the pace, the impact on customers, and the trade-offs between service quality and electric rates.
Thank you. Mr. Williamson, it's correct, is it not, that Power Forward was a $13 billion planned capital spend over the course of 10 years?
Yes, that's correct. 13 billion over 10 years. Those numbers are correct.
Thank you. And is it correct that in the sub 1146 DEC rate case, which the commission has already taken judicial notice of in this proceeding, that Duke requested special rate making treatment for Power Forward costs and requested the establishment of a grid rider to recover those costs?
Yes, that's correct. They did make that request.
And also in that proceeding, they made a request in the alternative for special accounting treatment, namely deferral accounting. for those costs in the event that they were not authorized to be recovered through the grid rider. Is that right?
That is correct.
And the commission denied both of those requests in the sub 1146 proceeding, correct?
That's correct.
Thank you. Can you take us to figure 14 on page 46 of your testimony?
I'm there.
Can you explain what this shows?
Yes, so figure 14, page 46. So this is actually figure 1 from the technical summary, which is our exhibit 1. But what it's showing here is the company, I think, was illustrating that 2 scenarios, and they're showing DEP and DEC in the same figure, but they're showing that what the current level of non-med SAIDI was, and given 2 outcomes. One, trends without the plan, meaning without power forward, and projections with the plan. And so what it was tempting to show, the illustration is that if what were those outcomes for SAIDI in about 10 years later. So we're seeing a reduction down to a target of about 90 for SAIDI with the plan, and potentially going to 225 without the plan.
And does the public staff have a position in terms of whether ratepayers got bang for their buck on power forward investments?
Well, and I think it's been pointed out, Power Forward, you're right, was not approved as a plan, but as we've shown, the components, the programs of Power Forward that are in our exhibit 1 are, continue to this day. SOG has been talked a lot about, distribution hardening and resiliency. But yeah, if you will turn to so on page 21, our testimony, figure 5. So this is DEC's non-med SAIDI from 2015 through 2025. And you can see that, there's fluctuation over the years, but the trend line shows stable to slightly increasing over that time. And I'll point out too that I think these are what we're showing here. All of our reliability numbers are North Carolina only. I believe the company in their presentation and guidance, Mr. Witness guidance testimony was DEC system. So slight difference there. So in this case, 2025, the actual SAIDI was 170, and I think in guidance testimony, they said it was 164. So we're seeing there was a flattening of SAIDI. And then also you can turn to figure 6, which is non-med SAFE. We have the same concern there. That's the frequency of interruptions. That is also an upward trend. And 2 more figures, figures 8 and 9. Those 2 are illustrating the SEMI index. So that's the customers experiencing multiple interruptions. SEMI 2 would be a customer that had at least 2 sustained outages a year. And then SEMI 4, 6, and 8 also reflect that number as well. So in figure 8, you can see this is adjusted per customer. So we've the company's added about 330,000 customers from 2015 through 2025. And they began monitoring the SEMI indices in 2019. So that's where this picks up in 2019. But you can see from figure 8, starting in 2019 through 2025, the percentage of customers that are in those buckets of SEMI 2 and 4, they've gone up a little, but there's been no improvement. If you flip the page to figure 9, this is showing the SEMI 6 and SEMI 8. So these are customers having 6 or 8 sustained outages. Those trends are accelerated more. Matter of fact, the SEMI 6 is about doubled it was in 2019. SEMI 8 is almost over 4 times the amount of customers that are experiencing 8 outages a year. So yeah, I think one of our and Mr. Thomas, Witness Thomas, had that same concern, is that we're not saying there's programs that shouldn't be done, but we're seeing a concern with the pace of capital put in place, and we're not seeing what we think should be improvements in reliability. And the company indicated in that Power Forward illustration from the technical review that, if we spent on the programs that were in Power Forward, and that has happened, we should see a declining SAIDI, which is an improvement for customers. And so, yes, to answer your question, yes, I don't think we've not seen what we were expecting or hoping for. And now we're seeing continued projections of more distribution spend, but no firm, hold on what kind of improvements we're going to get for reliability. Mr. Thomas may have additional items on that.
I think that summarizes it well.
Thank you. And to the extent anyone on the panel knows the answer to this question, please feel free to answer it. But is it fair to say that after the commission denied special rate making treatment in the sub 1146 rate case for the Power Forward investments and the grid rider, that Duke then went to the legislature and started lobbying for multi-year rate plans?
Commissioner McKissick, respectfully, I object. I have been patient. I've allowed counsel to ask some questions of this panel to see where she was going. However, it's very clear. I even went back and looked at Sigford's testimony, cross-referenced that to public staff's testimony. I see no issue and dispute that Sigford is attempting to elicit testimony on, and I respectfully object.
I'll be happy to save this line of questions for the public staff's policy panel, which I think it's in the public interest to ask them some questions along these lines. Thank you.
Thank you. All right, well, that moves us on to CUCA. You take the center seat.
Good afternoon, Chris Dodd on behalf of CUCA. Just a few questions for Mr. Thomas or Mr. Williamson. So turning to page 71 of your testimony, you discussed the hazard tree program, and then going on to page 17 or 72, list a spend for it of just under 91 million. Is that correct?
That's correct.
And as regards the hazard tree program, this involves an ongoing program that supports the removal of trees that present a danger to Duke's assets or grid as they are identified over time. Is that correct?
Yes, and as kind of summarized my testimony, it's distinct from typical vegetation management, which involves routine clearing of trees and vegetation within the right of way. The hazard tree program involves removing larger trees that are outside the right of way that might fall, that might be damaged, dying, that might fall into the lines. So Duke has a program where they kind of go out and scout for those. I believe there's drones and LiDAR involved in that analysis to find those trees. And then the costs of that removal are capitalized, added to rate base in a similar manner as the initial clearing of the right of way is capitalized. And so yes, that sums up the program, I think.
Thank you. You're aware that in the last DEC rate case, CUCA challenged whether this program should qualify under the statutes for inclusion in the multi-year rate plan.
It's been a while since reading testimony from that, but I'll take your word that CUCA challenged it.
And that the Supreme Court affirmed inclusion on the grounds that there was sufficient evidence to support the commission's conclusion regarding the hazard tree program.
Again, I'll take your word for the Supreme Court decision.
So is it the public staff's position that removal of trees not yet identified represents a discrete and identifiable capital project that results in a capital asset being placed into service during the first year of the MYRP?
So Mr. Williamson may have more to add here, or Mr. Lawrence, because I know there's hazard trees and transmission as well. But I think the way we have looked at this program is that it is not a discrete item in that there are specific trees identified within the MYRP that, this oak and this elm are going to have to come down. But we have generally recognized that it is a program that Duke is executing. They have a kind of a defined budget and outlook for the scope of the work that they will do within each rate year. And then the costs are also split up into monthly projects. So it's not like the entire, each rate year has a amount dedicated to hazard tree. But as I've spoken about before, that is split generally for distribution into 12 monthly programs. So essentially every month you have a certain amount coming into service as a capital project related to the hazard trees. And so when you build your rate year 1 and rate year 2 rates, you kind of have, 100% of the depreciation expense and return component for the January hazard tree, 11/12 of the February, 10/12 of the March, and kind of on and on throughout that program. So it's not like the entire 30 million or so is capitalized as if it's coming into service on rate year 1. So there's kind of a discrete pacing associated with this project and program that is reflected in MYRP 1 rates.
And I'll add too, since Mr. Thomas did mention that the transmission does have the same program, my understanding is that the distribution and transmission programs are essentially identical. The only difference is the right of way, which is being cleared.
Would you agree that just because Duke has a program with a monthly budget does not necessarily mean that it's using that program to place capital investments into service? Capital assets, rather?
Sorry, can you restate that?
Sure, maybe I'll phrase it a different way. You understand why it might be difficult for the public to understand how the removal of trees creates a capital asset that should be placed into rate base that they would have to be assessed a rate of return on.
Yes, I think the capitalization of hazard tree and the expensing of vegetation management is obviously a very complex differentiation that gets into accounting and GAAP and all that. And so, yeah, I think regarding the public's understanding of the two programs, I can see how there would be confusion between the two.
And I would follow up and say that the hazard tree program, it's an as found item. So it's not like we're going to go out and make sure we find this much capital in a month, but they're allowing for the finding of those trees, which Mr. Thomas talked about. There's technology, there's drones, LiDAR, there's site inspections, the actual trimming done on an annual basis. They're evaluating and looking for trees that are meeting a hazard tree definition. So as they find them, they're removing them. And so there's a budget for that, but it's truly an as found item.
So if they don't find any trees that need removal, they would have zero spend.
Yeah, the spend is going to go along with if however many we find, that's what's going to be included in the program.
Thank you. No further questions.
Okay, with it being 12:28, we're going to go ahead and break now for lunch. We'll return at 1:45 and continue cross-examination. EDF will be up next. Thank you. Vandervoort did have to leave. He won't be back this afternoon. It's still related to that ongoing family emergency that he's experiencing. So I just place that into the record so you'll all be aware. We can go ahead and resume with cross-examination from Environmental Defense Fund next in the queue.
Thank you, Presiding Commissioner McKissick. Ben Smith from Environmental Defense Fund. Good afternoon. I just have a few questions. Ms. Kress asked a number that I had, so I'm just gonna jump right into my remaining few. Generally speaking, is the panel's testimony that despite an increase in recent years in spending on distribution reliability investments, DEC has actually seen a downturn in its reliability metrics?
Yes, when we compare and look at the amount of distribution capital placed in service from the 2015 to 2025 period, the corresponding reliability during those times. And when we say reliability, we're looking at the SAIDI, SAFE, and the SEMI indices. So we're looking at that. And yes, as I spoke earlier, I figure 5, 6, 7, 8, and 9 are discussing those reliability metrics. And yes, SAIDI over that time has been, there's a lot of 170s in the numbers. If you look from 2015 through 2025, there are some ups and downs, but as was talked about earlier, the Power Forward Carolinas envisioned spending on the programs that we're looking at today and seeing a significant reduction in SAIDI down to the 90 level. That was projected. So I think the lowest SAIDI we've had in this period has been 153, and that occurred in 2021. So the SEMI indices, like we said earlier, are continuing to increase, no deflection downward. So yeah, so I guess in general, we're seeing more spending, but we're not seeing improved reliability.
Has your investigation led to a reason why that has happened?
We also said earlier, a lot of the programs that are being done, they're not bad programs, but our concern is with the pace of spending. And let me talk about SOG for a minute. So self-optimizing grid. I think earlier Witness Guyton shared with the commission on how it works, but want to maybe just address for a minute. And I believe I got it on pages 42 and 43 of my testimony. Let's see here. It talks about the SOG enablement process and what it takes to get SOG where it's ready to go. So in the analysis the company follows to implement and to deploy a SOG circuit, they have to look at first the capacity of the transformers, because if we got 2 substations with circuits coming from each one and we want to tie that circuit together to form a team. So if we get an outage in one circuit, the other circuit could come along and pick up some of that load. We analyze the capacity of the transformers to make sure that they can pick up that extra load. The wires that have to be carry that increased capacity, we have to determine, is there enough capacity there? And if not, we've got to change out the wire. That wire is usually going to be larger and heavier, so that puts more loads on the poles. So now we're going to maybe change out the poles. And if we've got existing oil reclosers that were in that original circuit, they're going to be changed out and put electronic reclosers in there to allow for that segmentation of the circuit. It gives us better communications and better relaying capabilities. So to get a SOG to where it's a circuit to where it's ready to go, we've done a lot of analysis on the circuit, and we've got potentially new transformers, new poles, new wire. So all of that to get the SOG team to where it's ready to do its intended purpose, and that's to reduce outages. But part of that is now we've got a lot of new equipment there. So to answer your question, no, I don't think there's an understanding why that's not happening. We know there's a lot of effort there to bring the system up to a better capability. And so that is disappointing that we're not seeing the reliability, even though we're putting new equipment, more automation, more communications in the field. Thomas may have more to add.
Yeah, if I could just add too, because I want to note for the commission that, the distribution, as we've talked about before, and as the DC witnesses have talked about, the distribution grid, let's not call it aging. It is just becoming more, we're approaching its end of life. Many of these assets, right? A lot of this was built decades ago and is kind of reaching the end of its life. And so, as part of the stipulation, we approved programs such as infrastructure integrity, right, which is a condition-based program to replace aging and end-of-life equipment in order to ensure that they have that budget to replace failing poles, replace corroded conductors before they fail. That condition base is what we're really looking at, because it is true that spending is needed there. And I think, why the service quality is getting worse. I think if DEC did not spend $1 outside of the amount necessary to simply add new distribution circuits and load, you would see quality go down as equipment ages and we see more and more failures associated with transformers and breakers and reclosers, right? So the amount that's being spent, we are just trying to make sure that it's targeted in the right place. And I think our testimony, both Mr. Williamson and mine, highlights that in some cases we think that the spending could be better prioritized in order to increase the system average SAIDI and look at the SAIDI and safety in different zones and increase those problematic zones, rather than spending significant sums of money on circuits that have an average SAIDI of 80 or 90, right, which is already performing a lot better than the system average. You can only squeeze so much of a customer minutes interrupted or customer interruptions out of a circuit that is performing significantly better than the system average versus a circuit that has a SAIDI and safety of 300 minutes per customer. Reliability improvements there might be able to get you much more bang for your buck in terms of reduced customer minutes interrupted or customer interruptions. And so why the quality is going down, I think a big driver of that is simply aging and degrading equipment that must be replaced. I think our concerns are really around the focus of that spending, the pace of that spending, and the justification for that spending to make sure that customers are willing to accept, I think, some costs associated with quality and service, quality improvements or maintenance. But that acceptance and that willingness to pay is not infinite.
And just let me add, point you to table 2 and 3 in our testimony. Table 2 highlights where we are today with the status of equipment. The first line substation circuit breakers, we're 69% of the fleet is now vacuum circuit breakers. So the oil breakers have been replaced, which are usually higher in maintenance, but the vacuum breakers have better communications and better relaying options on it. The next line, these are the line reclosers. So think of this, these are the segmentation devices out on the circuit that are helping the SOG to break out a portion of the segment or the line that has had an outage. So these reclosers, now we're at 88% of the fleet is electronic, replacing a lot of oil breakers that had reclosers that had been in the field. So that's an incredible amount of infrastructure that's new. And then the line disconnects, the last one, that's about 5,000, they call them trip savers. So these are the like the little mini reclosers that are off of the main 3-phase lines. Then you'll tap off one phase to go down to the neighborhoods. So that's an automatic device. So we got more automation in place. The AMI meter deployment is complete. And so there's quicker acknowledgement of if a customer has an outage, through the AMI system. And then table 3 looks at SOG deployment. Right now, 64% of all DEC customers are connected to a SOG circuit. And so that's how many customers are on it. But like I said earlier, all that analysis to bring that SOG circuit up to ability to do its job, that analysis has been done. So we got basically 64% of the system that has been renewed through the SOG analysis.
Thank you. I want to touch on something just to make sure I understand. Mr. Williamson, you mentioned capacity, and so it's going to trigger a question that might be apples and oranges, and please tell me if I'm barking up the wrong tree here. I can use a number of other verbal things there, but increased demand on the system, does that impact reliability as you all have investigated it on the distribution system? Increased load, I should say.
I would say increased load certainly drives the need for investments in conductors, breakers, transformers to handle that increased load. Whether it drives additional failures, certainly it can, right? If you operate a transmission line or a certain device at or almost above its limit, its operating limit, for longer periods of time, you might see failures become more likely, right? There's a kind of failure curve. And, if you're operating, if you have to operate some sort of switch or recloser more often as load grows and you have to shift it from circuit to circuit, more operations increases the likelihood of failure. But certainly we see that there is a significant amount of spending in the MRP and the historic period associated with capacity uplift programs, the area capacity uplift program, the capacity program within the substation in line. So they're responding to that load growth, I think, in a measurable way. But, I think your question really speaks to the overlap between, capacity programs and reliability programs. And I think there is a lot of overlap. It's hard to classify any single investment as solely reliability or solely for capacity because the concepts can become really interlinked.
No, that's good.
Oh, thank you, Mr. Thomas. You hit on exactly what I was hoping to do. This, I think, my last question. You all, I believe, are familiar with the load forecast and the expectations for new load coming on. Going forward, does the public staff have concerns about the diminishing results in the distribution investments, particularly considering that we are looking at a whole bunch of more load coming on?
Can you clarify what you mean by diminishing results, or are we talking about diminishing service quality from distribution investments, diminishing ability to meet new load, or?
I'm talking about, I asked a question about investing more money with worse results. I think I opened my line of questions with that. And now I'm saying if we can expect more load to come on, presumably you would be able to expect more investments into the distribution system. And if so, are you concerned that it'll be throwing good money after bad?
I'll try to answer that as best I can. And maybe I want to add anything, Mr. Williamson. I think the company does have an obligation to serve. And so when a new development is built, residential development or some sort of commercial or industrial group that's connected to the distribution system, or, just expansion, more families moving in, more EVs, more electric heat pumps, right? Duke has an obligation to not only forecast that load at the distribution level, which they do with a tool called Morecast and their advanced distribution planning, which hasn't been discussed much in this proceeding, but has been a focus of, I'm sure, many engineers' time over the past several years. They try to forecast this. How is this happening? How can we make sure we meet that load growth? And I think it's our expectation that, we are not spending a bunch of money to replace an old transformer when Duke knows that that transformer will have to be upgraded in terms of capacity and an ability to handle increased load in another 5 years. And I think the grid plan that Duke uses to execute on their MWR, on their projects, does take into account, expectations of behind the meter generation and electric vehicle adoption and load growth, and what is your summer peak and when is your winter peak, and when are we going to start seeing thermal overloads on our conductors. And they try, I think, to coordinate through the substation and line program, both replacing end of life equipment, and if a capacity increase is expected in that area, to also do that at the same time. Because I think it is a huge waste of time and ratepayer funds to replace an old transformer before it fails, to avoid a quality hit. And then you have to go and replace that again in 5 years because half the neighborhood got electric vehicles. So obviously Duke can't predict the future, but they are, I believe, making an effort, looking out over, I think, 5 years or so, on expected distribution system growth and attempting to coordinate reliability improvements with capacity improvements. I think our testimony just points out that we have concerns sometimes that the reliability focus may be misplaced and that capacity, may be preemptive. But overall, I think there's a method to the planning of the distribution system that has evolved a lot over the last several years. And we just want to make sure to continue to improve that methodology and to make sure we are also taking into account customer affordability and willingness to pay in the equation, and the algorithm that's optimizing these investments should consider that to an extent possible.
Thank you. No further questions.
Thank you. Next in queue is the North Carolina Home Builders Association. Not seeing anyone on behalf of the home builders. We'll now move to North Carolina Justice Center et al.
Zoning Commissioner McKissick, no questions from JC at all.
Okay. In which case we will allow an opportunity for redirect.
Just real quick and so that we can move on. I know y'all have talked about going back to 2015. You've talked about some of the concerning trends that you have, but you've also said that you do expect, obviously, that Duke will continue to invest in the distribution system. Are there any, you have recommendations on pages 108 to 113 of your joint testimony, and this in particular is Mr. Thomas and Ms. Williamson. Are there any other areas while you acknowledge the need to invest, recommendations that you would make that you've not articulated yet, that you want to share with the commission about making smart investments?
Yeah, there is one on page 101 and 102 of our testimony regarding vegetation management. In there, figure 23 points out and it does a comparison of total SAIDI compared to equipment failure SAIDI. And so you can see there, the bottom line, that's the equipment failure SAIDI, and it's going from 2020 through 2025. That trend has continued. Matter of fact, there's been about a 45% increase in SAIDI from 2020 to 2025. In the corresponding time, vegetation SAIDI has been flat to a slight downward trend. And I point that out because during the spend during that time, there was about 7.2 billion in distribution capital placed in service, and that's affecting the equipment failure. The vegetation management only had about 642 million in there to do its distribution vegetation management. And so, one thing we asked in here was for the company to consider reassessing, looking at how I'd say pretty good performance with vegetation management compared to the equipment failure. It may be good to consider looking at reassessing the vegetation program, either trimming more frequently. The company has just changed to a condition-based approach instead of a calendar-based approach. And I think going forward, that could lead to some good results to identify areas of vegetation that are more problematic, and we can address them sooner. So I think that's a good step forward. But I think given the ability to achieve some good results for reliability, now might be the time to continue that approach and try to leverage the good results with vegetation management. That's good. Thank you.
Does that cover the redirect?
Yes, sir.
All right. Then we're going to go ahead to commissioner questions. We do have some questions from commission staff, which you will need to have answered dealing with Mr. Guyton's testimony. And we will also, at an appropriate time, need to go into a confidential session to ask a few questions as well. And I will let you know before we lead into that. And of course, ask for anybody to exit the hearing room that has not signed a confidentiality agreement or non-disclosure agreement, as the case may be. So Mr. Thomas, Mr. Williamson, can you succinctly articulate the public staff's position on outage cause coding and major event day designations and the concerns you share with the company's methods not being transparent as provided on pages 31 through 32 of your testimony? I'll give you a minute to get to 31 and 32.
I'm there, Commissioner.
Okay.
Oh, okay. So really, I think this was pretty straightforward. So in Discovery, the company provided the list of all their days that they had designated as major event days. And so that's those are designated by a certain number of outages, need to exceed a certain threshold. If we exceed those outages for account for the day, then that's considered a major event day. And then all those outages are removed separately and not recorded or reported as non-mid days. And there's averaging about 7 to 8 days a year that are major event days. So the vast majority are non-mid, but for the ones that are, they need to be separated out. And so the concern here was on this particular outage day, the company listed the outage cause as winter storm. And this actually occurred at a substation in Durham where the company was doing work inside the substation. They were needed to dig a couple of holes to install some poles. The digging of the holes ended up impacting some control lines that created the outage. In Discovery, we also saw that about 99% of all the outages that day were at that one location. And so our contention is that that was equipment damage that caused the outage and that it should be reported that way instead of it being winter storm. Now, in that particular day, the temperature ranged from about 33 to 55 down to 28 and back up to about 50. There was no precipitation that occurred that day. Winds were about 10 miles an hour. So our contention is that this was an equipment damage outage and it should be reported that way. And there's precedent for that. Back in the winter storm, I believe in 2022, one of the outage days was, ME days was listed as low constraints, even though it was obviously impacted by the weather that time, but the MED cost that the company placed in the cost of the day was low constraints. So our contention is that a day like that happened at the substation in Durham should be recorded as equipment damage and not as a weather event.
Thank you for that explanation. Besides the metrics you suggest, how would you restructure the reliability reports that are filed in E100 sub 138A so they give the most valuable information to the commission on the overall health of the distribution system?
We've made recommendations and I believe the company has agreed to them. Right now, the report that's in E100 sub 138A, it's limited to basically the last 12 months. So every quarter that is filed, it's basically picking up the last 12 months of data. So we have asked for it and the company's agreed, I believe that we asked for 5 years data. So now we got a little bit more history. So every report that you look at, you're going to see the last 5 full years plus in a separate section, the last 4 quarters. So we can see some long-term history, but we can see current volatility if there is on a quarterly basis. And we've added SAIDI and safety will continue to be there in a non-med and med basis. We'll have the number of major event days so we can see what's been happening as far as the frequency of those events. And we're adding the semi indexes. So now we can see if those customers that are experiencing multiple outages, what's the trend with those. So I think going forward, that report will be much more transparent and much more informative.
Thank you. Now, paraphrasing Mr. Guyton's rebuttal, he contends that your evaluation period was not appropriate for assessing DEC's SAIDI performance relative to when DEC began its distribution investments. What is your reaction to his testimony?
And Commissioner, that's why I've talked about earlier, that's why I went back to 2015 to begin this evaluation, because what we were experiencing here in the PBR1 period, it didn't just start there in isolation. we go back and look, starting in 2015, which is 2 years before the Power Forward program was presented. And what we demonstrate in figure 13 is that the distribution capital placed in service began an increase from 2015. If you look, except for COVID, we've had steady increases. So the input that the company is placing as far as new equipment has been going on since 2015. The downturn in COVID obviously occurred in 2020 and 21, but in 2022, it jumped back up. And I'd say that was not a beginning to increase. To me, that was a return to the trend that had been going on since 2015. So I would say that's our response, is that this isn't a PBR1 event that's just gotten started. This trend started in 2015.
Okay. Now, Mr. Guyton also speaks about the impact of hotline tag outages on SAIDI. This is a clarifying question since you all are distribution experts. Is it not possible to develop a SAIDI metric that excludes the hotline tag outages?
So in his testimony, he talks about the hotline tags having an impact on total SAIDI. And the hotline tags is under the category of planned work. So if you look at SAIDI, total SAIDI, you have multiple outage categories. The largest one is vegetation. Basically, 40 to 43% of all outages in total SAIDI is vegetation. Next is equipment failure. We're in the 20% range for that. Next is public accident is actually the next one, and it's about 16 to 18%. And then planned work. So these hotline tags that Witness Guyton talked about are in the planned work outage category. It's only about 4 or 5% of total SAIDI. And in the year that he's talking about, let's see, that was 2023. The year before, in 2022, hotline tags accounted for about 7 minutes of total SAIDI. The next year went up to 14, and then back down to 9, and we're back at 7 minutes. So there was a little eruption there, and they explained that there was some issues with relay settings. They analyzed that, figured out the issue, and corrected it, and that's why we see a return to normal ranges in the last 2 years. So I would not say there needs to be a separate category for that. There was an issue that occurred. The company identified it, analyzed the solution, and was able to apply that and basically return to a more normal mode. And Mr. Thomas, do you have anything else to say?
Yeah, I think Ms. Roseman summed that up well. I think what he's trying to say is, the trend is either slightly increasing or flat, generally, even if you take these into account. But I think our hope is that service quality improves, right? We don't want to see Duke spending all of this money and we stay flat, treading water, or get worse on service quality. We know that service quality is important to some customers. Nobody likes to have a bunch of outages. And so we want to see that get better. And so to the extent that DC is, managing its hotline outages, minimizing them to the greatest extent possible in order to do this work in a timely manner, increasing the interconnectivity of circuits to ensure that they can move certain load to another circuit while they're doing repair and modernization work, and then move them back when they're done. I think that's all great. And our settlement, I think, reflects our approval of MORP projects that we feel is going to help customers and help restore the grid. But we do expect to see, we would like to see service quality get better. And so that's what we're going to continue to monitoring. And I think the improved reliability reporting standards that we agreed to in the stipulation will help us and the commission see a broader picture, both over time and over different aspects. But I also, I think the difference between reliability and resiliency, which is discussed in Witness Guyton's rebuttal, I think that is an important concept. And I think it's not just North Carolina, the public staff, that kind of struggles to understand how to quantify the benefits of both and the difference of both and where there's overlap. And so I think that's a conversation that's being had at the national level all over this country. And so to the extent that we're going to continue to work with Duke on, the grid plan investments that they're executing, the costs that they're seeking recovery, the service quality metrics that they are reporting, and how they are seeking to quantify the benefits of resiliency, which is much more difficult than just using the ICE calculator. I think we'll continue to work with them and hope to return benefits to the ratepayers of North Carolina.
Okay, now, Mr. Thompson, on page 12 of Mr. Guyton's rebuttal testimony, he presents an analysis comparing actual SAIDI to a model without SOG or self-optimizing grid scenario. We want to understand your evaluation of that analysis. In your view, is the methodology underlying that counterfactual, that is without SOG, sufficiently explained and supported by the record?
So I think we did serve some discovery and attempted to look into this. I think we also had, after I think the last rate case, we had some quarterly or biannual reporting on grid improvement plan costs and metrics. And I think to the extent that this is looking at activations of SOG devices, I think it can provide a directionally correct estimate of customer minutes interruption and customer interruptions and how that's being reduced and avoided. We had a lot of discussion about the cost benefit analyses underlying SOG in the last rate case, and we continue to have those conversations both internally and with Duke. I think what I have not had time to validate and work on is really comparing these savings to what was estimated in the cost benefit analyses that underlie the investments that were made here. And so, I've spoken before about how some of the reliability, the monetized reliability benefits associated with some of these reliability programs kind of beggar belief, right? I think there's a transmission program that Mr. Lawrence can speak to that estimates like $17 billion of customer reliability benefits. And I think the monetization of those can be one thing, but I think what we're interested in is really maybe a better accounting and tracking for when they come in 2023 or 2019 or 2026 and say, we want to spend all this money on SOG. We expect it to achieve this many CMI and CMI customer minutes interrupted and customer interruptions. We think it'll reduce it by this amount. I think what the next step is really making sure that we are understanding when they come in for cost recovery, what is the actual performance of those investments in the time since you've made them, and how is that comparing to the cost benefit analyses? And so to that extent, I think Mr. Guyton's rebuttal does make a good point that without these investments, there is a potential for things to get even worse, right, than they are. But to the extent that SOG is one program that's easier to measure, because you can know when a recloser activates, when a circuit gets segmented, and when power is restored from another substation. So those can kind of be tracked. But I think I can't speak exactly to the accuracy of this relative to those cost benefit analyses, but that is the metric I think I'd be most interested in digging into.
And of course, the follow-up was how much weight, if any, should the commission place on that analysis?
I think, I guess I'll put it like this. I think the point he's trying to make about the degradation absent grid improvement, I think that is a true statement. And I think that certainly weight should be given to that simple fact, right? If you didn't make these investments, maybe service quality would have been worse. And how can we track that? And I think in the past, the commission has, I think in the 2019 rate cases, when grid improvement came through, the commission did direct Duke to file reporting. Again, I think it was quarterly or annual on, estimated quality improvements from SAIDI in terms of activations, device activations, how many times device failed to activate, and then an estimate of, how many customers were able to avoid a sustained outage and what impact that had. That was certainly helpful for us. We use that. I think that reporting is no longer continuing, but if the commission was interested, I think in getting a better picture of that, certainly they could. I think one good way to validate that would be to look at and have that reporting happen maybe on an annual basis and make some effort to compare those actuals to those estimates of the CBA, the cost benefit analysis that was used to justify those projects.
All right. Now, when Mr. Guyton was on the stand, he stated that he was not involved in the development of reliability PIM. Mr. Williamson, since you are a distribution and PIM witness, I would like to ask you about the reliability PIM at a high level. Could you explain why the public staff believes its proposed zone-based reliability PIM is a better approach than Duke's proposed system-wide reliability PIM?
I'd say very shortly that, the current reliability PIM looks at the whole system, and our effort here was to say, let's give the opportunity for the company to earn a reward or avoid a penalty actually by looking at each of the zones. There's 5 zones. And so we were thinking about it from a transparency for the public to say, are we have pockets of poor reliability? If so, where are they? And, for the company to be able to look at those as well, which I know they do, and address them. But to me, it was just, it was there for transparency to say, let's look at each zone, give the opportunity to reward good performance in the zones that were doing well, and let's know where the poor performance is occurring.
Now, do you foresee any implementation challenges associated with administering a zone-based reliability PIM?
I do not, because through discovery, all the information we needed was provided at a zone level. So I think it's really just a reporting metric to be able to segment that. The company to me did not indicate that there was going to be a huge effort to be able to report in a zone-based way.
And what is the public staff's position if the commission were to consider a lower tier penalty threshold, such as 170 to 200 minutes for the reliability PIM SADI instead of the zone-based reliability PIM proposed by the public staff?
Commissioner, are you saying that take the current format and just lower the thresholds
correct,
instead
lower
of doing the zone-based?
That's exactly correct.
I think one of our concerns with the current PBR2 proposal from the company was that the thresholds were too high. So I think it would be an effort, move in the right direction to lower those thresholds. And so if you chose to do that versus the zone-based, I guess if I take the trade-off, I'll take the lower thresholds and give away the zone. If that was my option, I'd say, yes, I'd definitely take the lower thresholds.
Got it. Thank you. Now, Mr. Thomas, a few questions about the ICE calculator. Do you know at what point did utilities, including Duke, start navigating towards the ICE calculator to conduct the CBA analysis?
That's a good question. I am certainly in the last general rate case in 2023, they were using that calculator, and I'm fairly sure, subject to check, that it was also used in the 2019 rate case, which had the grid improvement plan included. I'd have to look back at that, but I'm pretty sure they use that. There's been iterations. I think the LBNL, Lawrence Berkeley National Laboratory, I think they were either working on or recently released kind of a version 2. I think a lot of our criticisms in past were, using national data instead of local data, using national kind of mixes of different customer classes versus Duke specific. I will say that when I've interacted with the tool during this case and when I interacted with the tool in the past, it's become much more sophisticated, much more ability to customize and tweak to get the outputs that then can be used in kind of the analysis that's here. So I think there's a lot of effort being taken there, and I'm subject to check. This might be a good question for a witness Guyton on rebuttal, but I believe Duke is even engaged with LBNL along with other industry voices to develop and refine the ICE calculator to be used, in future proceedings like this, because quantifying that amount it can be difficult to quantify the value of an outage or an avoided outage. But again, I think, when I look at the ICE calculator, I think it is a great tool to when you have too many, you have more distribution projects that you want to do than you have money to spend. It is a great tool for ranking those projects in terms of reliability and saying, well, we really let's make sure we get the best benefit cost ratios projects in our proposal, and then these ones that don't have great cost benefit, we'll save them for later, or we'll do them another time, right? I think that speaks to the pacing concerns that we have. I think if you're using the ICE calculator to justify action versus inaction, I think I've said this before, it will almost always tell you it's beneficial to do action, particularly if you have any commercial or industrial customers on that grid, right? The benefits are just, they're significant, they result in some benefit cost ratios. Again, I'm going to look at Mr. Lawrence here, but I think there's like 44 times the benefits versus the cost for some programs, and it gets very high.
Right. Yes, and I'll echo what Mr. Thomas said. The benefits he's also referencing on the program level, when you look at some of the individual projects, and let me find the exhibit, the FOG exhibit. FOG exhibit 6. I'm just turned to page 18 of 40 here. But you can see some of these projects listed have ratios of 224, 218, meaning that for every single dollar spent, there'd be $224 in value returned. And as Mr. Thomas said, that this type of CBA is useful when comparing projects to other projects, but for the real value that customers receive, it's not as useful to tell that information.
Very good. Now, is the ICE calculator the most appropriate way to evaluate distribution investments? For example, when Mr. Guyton was on the stand, he could not recall an example of a distribution project with a benefit to cost ratio of less than 1 that the company discarded. Broadly speaking, how would you address a potential concern that the ICE calculator seems overly generous in terms of letting distribution investments cross the CBA thresholds?
So I think, I think I'll start and add, but I think when we look at the ICE calculator results, I think our recommendations, our testimony in this proceeding really speak to, our concerns about pacing and the amount of projects that are included in the MRP and in the historic period. And I think the commission has a lot of authority as well to look at those concerns and say, is this the right pace? And are we spending too much on distribution relative to what customers are willing to pay? I don't know of any alternatives to the ICE calculator that are kind of widely accepted. I think certainly Duke could spend a significant amount of money to perform willingness to pay surveys, and send out surveys to industrial and commercial and residential customers and say, how much is it worth to avoid an 8-hour outage? I mean, that's kind of what the LBNL study does, right? It looks at national averages, and it does send out surveys, particularly to industrial and commercial customers. But I think at a time when, particularly, we hear from a lot of residential customers that are very concerned about rates, and we point out in some of our other testimony that Duke DEC's rates relative to the national average, the gap is closing, right, between DEC's rates and the national average for residential, commercial, and industrial customers. And so I think we expect Duke to exercise discretion in its selection of projects and to recognize that there is a point at which the price increases as a result of reliability investments outweigh the actual willingness to pay of customers in North Carolina, both for customers here and customers considering moving to North Carolina to open businesses or factories. And so that it's a very difficult line to draw. I can't say any CBA, any cost benefit with a ratio less than 4 should be discarded, right? Move the floor. It's very hard to evaluate that because again, some of these investments are adding capacity, adding new customers, increasing resilience in addition to reliability. So it's kind of a case by case basis, and I expect that we will continue. This MYRP was the first time we really looked at the distribution MYRP and applied some thresholds, right, to steer investments away from circuits that are performing well already above the system average. And I expect that we'll continue in future MYRPs, continue to apply a similar standard, similar analysis as we hear from customers more and more concerned about rate increases.
And I'd like to add to, not directly answering the question, but I think very close and enough worth mentioning is in the stipulation that the public staff and company have entered into. Item 21 of the items that have been agreed to is that the company has agreed to provide additional support for its cost benefit analysis process, including the formulas and more technical explanations of the value models used in its next general rate case. So we are taking steps to get there to the point of that question that you have asked.
Thank you. Now, on transmission investments, how should Duke consider the results of the CBAs when selecting and prioritizing transmission projects for the NYRP? Are there other criteria that you believe Duke should consider with more weight?
So that is a somewhat complicated question. And as I've addressed in my testimony, part of there were all but one program I said that it was necessary for customers believe it was appropriate for an MYRP program because each of those had a specific need that was measured. It was either studied through NERC studies, through stakeholder processes to get to the optimal solution, other requirements that may be made to resolve general system conditions. And in those situations, cost benefit analysis doesn't make a lot of sense to use it. It's if the question is to implement the project or to not reliably serve customers or to not comply with standards, it's not really a great comparison. So as I previously stated, that when you're evaluating projects against one another, evaluating potential solutions to a single problem, cost benefit analysis can be that was conducted in the manner that has been for these MYRP projects can be really beneficial to see where customers will get the most benefit. But it has to be siloed when ranking those specific projects, not for saying that a customer will receive this much benefit on their either in some way. I don't think it's really an accurate reflection of that.
Thank you.
If I can just add to,
by all means.
So don't want to, I feel like any conversation about selecting transmission projects would be remiss without mentioning multi-value strategic transmission planning process, right? And so during that process, and we've both been involved in that process, and they perform a lot of modeling runs to estimate benefits of these new transmission lines, like avoided capacity, reduced energy costs, I think reduced congestion. There's a series of benefits that closely aligns with Fork Order, I believe 1920, that requires this kind of long-term planning. So Duke is doing that. We are involved in that process. A lot of those projects bubble up into those come out and they get proposed in the CTPC, the Carolina Transmission Planning Collaborative. Many of those projects approved in the CTPC are found in the MYRP. And so that's one great way, interacting with the CTPC and the MVST process, to see kind of under the hood of how projects are being quantified, benefits identified, and how that's coming together.
Right. And even through that MVST process, one of the values that are input are outputs of the ICE calculator. So it is used in other processes.
Okay, very good. It looks like we've now reached a point where we will need to go into a confidential setting. So John, I would ask you to discontinue the live video and audio feed at this time. If there's anybody in the hearing room that's not signed a non-disclosure agreement or confidentiality agreement, you will need to exit the hearing room at this time. We will let you know when we come out of the confidential setting. I will look to exited the hearing room, so there's no need to tell anyone they can come in unless somebody was told not to come in during this section. That concludes the questions I have here from commission staff, but let me look to my colleagues to see if there are other questions relating to this panel.
Yeah.
Mr. Chair?
Yeah, and I think these will be a little simple.
Sure.
There was a discussion and a comment made, spending on distribution was yet resulting in reducing reliability. And the question was, were we throwing good money after bad? And I wanted to ask first, do we have any data that suggests that the decreasing reliability is due to a higher rate of failure in the new equipment?
Our investigation, I know we asked about equipment failure, but no, specifically asking about equipment failure of new installations. Don't think I have that granularity on that, Commissioner.
Okay, because I think granularity was some of the questions, because I was wondering if the outage was due to old equipment more than failure of new equipment. So then it comes down, are we generating any data on the marginal probability of failure, how it increases with age and use? And if we are tracking that down to a particular piece of equipment level, it could be, I mean, we're saying we're spending money, but it's not resulting in an improvement. But we don't know if we hadn't spent the money, if the reliability would have deteriorated even more. We also haven't determined how much we would need to increase spending to be improving reliability. And it sounds like we don't have the granularity to make that decision at the equipment level.
Just a moment. And Commissioner, I will say, in Discovery, we have some granularity on types of equipment. So that's why in our we do talk about where the location, overhead primary, underground primary. So we have that level of granularity. And I think we do have Discovery on, you know, how many pole type transformers, how many cross arms failed, but age, I don't have that.
And I think, you know, part of this is simply because, and I think this happens somewhat more maybe the distribution system, but, you know, Duke does not necessarily track the age of every single pole and device on the system. So sometimes it's difficult to tell. But I think this may be a good question to ask witness Guyton on rebuttal. But, you know, I think, for example, I talked earlier about corroding steel core conductors, right? So there's conductor technology has changed over time. And so I think when inspectors are going in, Duke personnel are going into the field, you know, part of this like infrastructure integrity program is a condition-based, you know, sounding poles and inspecting conductors. I think a lot of times the employees there can identify, hey, this is a very old style conductor. We don't even use this style anymore. It needs to be replaced with aluminum type conductor. And those are the ones that are showing corrosion and failures and showing a readiness to fail. So I think my understanding on just a matter like that, just from conversations with DEC and Duke employees on this matter, is that that's where they're seeing those failures. But certainly, I think witness Guyton probably has or can provide some information on, you know, the age classes and the types of technology and those failure rates. But I have not seen any evidence in this case to suggest that newer equipment is failing at higher rates than the older approaching end of life equipment.
And let me add, Mr. Thomas triggered a memory of a data request that we had early on, and had a discussion with the financial folks from Duke to say, because we're asking sort of this same question, but the issue is these are mass assets that go in, and the tracking of knowing, well, this transformer, pole type transformer was this age. It's not as easily done as we'd like. And so I think kind of set that aside because the effort to get to some age data that was relevant and impactful in a failure analysis was, was going to be a huge effort. And so I think we just set it aside for the time being. It's a pertinent question, and it's probably something we definitely would like to look at going forward.
Okay, and as I recall from your testimony, that the general sum and substance was that when it came to Sadie and Safi, that the metrics that you traditionally use in review, that they have not improved, they have deteriorated, notwithstanding the substantial investments that have gone in, and that Duke has failed to prioritize the substations and circuits that were in the worst condition for investment, and that frequently they were investing in ones that had superior performance.
Yes, so that's a good summary. We saw that the pace of investment was what we were seeing, and we looked at some circuits and substations to say, here's a set of substations that are performing above average, pretty good reliability, and yet they're receiving some investments. And then there's some substations over here that worse performance and not getting the same level of attention. So just a matter of prioritization and where we can get the best bang for our buck, I'd say, if you will.
Thank you. Commissioner Tucker. Commissioner Gaida, I'm sure you have a few in this area of your knowledge, expertise, and experience.
Perhaps. Gentlemen, I have one question that's not really reliability related, but there's been discussion. I think, correct me if I think this is the right panel that has dug into the distribution line extension plan, because I think that was in testimony. And so you guys can tell me whether or not you can address this, but there's been a lot of testimony about distribution line extension plan and service regulations. I think it's Commission's understanding that DEC has no equivalent transmission line extension plan. But our understanding, and this kind of came up in some of the large load discussions, but current practice, as I understand it, is DEC socializes the cost of transmission interconnection if the anticipated revenues cover the cost of the interconnection. I think in the distribution world, there's a 3-year revenue credit that is often applied. And I think we heard in testimony that a subject to check, a 1-year revenue credit was applied in the transmission world. I don't, and I don't personally know how consistent that is, but my main question for you all is, given that transmission level interconnections may very well be more common in the future in the era of large loads, and they were certainly not so common in the past, do you believe the Commission should direct DEC to develop a transmission line extension plan to codify this type of process or other processes? And if so, what sort of minimum procedures or provisions might it include?
Yeah, so I can maybe speak a little bit to this. I think, some of these recommendations we made in the large load panel, and I think our concern, and I'm going to paraphrase a little bit testimony that's not mine, so give me a little bit of grace, I hope. But our concern there was that we felt that Duke's analysis of the upgrades being caused by these large load customers was relatively perfunctory, didn't take into account things like the timing mismatch, the delay between when, we've seen Duke compare the cost of upgrades, transmission and distribution upgrades, to the annual revenue at that customer's full load, when that full load might not occur for 10 years, 8 years, right? And so I think we thought that it was not considering the load ramp, not considering time value of money and the delay in the cost being incurred and the revenues being generated. We also felt that, I think witness Dr. Sanganzi talked about this in his testimony, that essentially treating 100% of the revenue from that customer and comparing that to the transmission costs and the distribution costs caused by that customer, well, that's not very fair at all, because some of that revenue is paying for fuel how can you allocate costs of revenue to fuel and at the same time allocate that revenue to the distribution and the new costs that are being taken into account, as well as the use of the existing system, right? Because that customer is using that existing system and should be paying for that existing system as well, at least its share. And so I think if I had to maybe outline some concerns, are that definitely the timing of upgrades, the ramp rate would be a factor in any plan. I think in E100 sub 208, our comments identified how Virginia looks at this, and I think they look at like non-fuel revenue. We've certainly seen the large load impact analysis that Duke submitted in the carbon plan, E100 sub 207. We found, we presented an analysis of that in the DEP rate case that I think the panel on a couple panels ago talked about, but we want to make sure that the right types of revenues and how that's being allocated are being considered, and the totality of the upgrades being assigned to a customer, because a lot of times we might look at just one, right? I think in staff conference a couple of weeks ago, we talked about a data center transmission line, and I think we were comparing the full revenue to the cost of a single spur line connection, when in reality that customer required tens of millions of dollars of upgrades to connect that weren't in that math, right? And so if you look at just one upgrade and total revenue, and then just one upgrade in the total revenue, you are always going to be saying no CIAC. And I think there's also a desire, at least expressed in our large load panels testimony, that that these large load customers, because of the delay and because of the ramp, that a contribution aid of construction might be more common than Duke has traditionally thought it would be, because of this ramp and because of this delay. And is it fair to tell a bunch of residential customers that, hey, you go ahead and start paying for this transmission upgrade and this distribution upgrade, right? There's a lot of distribution costs that are incurred for these customers. And if it's not considered an excess facility, the majority of that cost is then assigned to North Carolina residential customers. I think the allocation factor for distribution to residential is more than 50%, subject to check, or very close to. So they're paying for a lot of it. And to tell them, hey, you go ahead and start paying for this, and in 5 or 10 years, once this facility gets spun up, you'll get some downward pressure on rates. I think that presents real equity concerns. So I think defining and codifying a transmission line extension plan that kind of takes into account those factors, or potentially having that be part of any working group that the commission might deign to spin out of this proceeding, certainly would be something that I think would help grapple with these complex issues.
Okay, thank you. A couple more questions on, so Chair Brawley just asked about reliability, and I'll try not to really retread his ground, but are you aware of, is it your sense, and I don't want you to testify on something that I should be asking the company, but is it your sense that the company tracks reliability outage causes at at a deeper level than perhaps you all have been privy to, or that you've been able to use in your analysis?
I mean, I know they look at, there's a primary outage. I mean, and there's secondary causes. They have an outage investigation team that will go in and look at outage events that are significant and really dig into it. So yeah, all that, the level of granularity, I can't speak to, but and there probably would be a good follow-up for the company. But from what I've seen, I think they're doing, I would say, what would be expected to go in and dig into, especially complex or high high outage number events, and to dig into it. So, but I think it'd be a good question to ask the company.
Okay, one of you mentioned your understanding that a lot of the assets, there's not necessarily a vintage or an age I think, Mr. Thomas, you may have said that, a vintage or an age necessarily known for a lot of smaller, high quantity components. And maybe I've missed this in testimony somewhere, but are you aware of inspection programs that the company utilizes to try to determine the condition of assets? Because if they can't immediately necessarily, if they don't know the age and they can't do it in an age-based method, but you're still trying to do reliability-centered maintenance, are you aware of inspection programs that have been, part of the company's overall reliability strategy?
Yes, I mean, they have, and Mr. Thomas may speak more to it, but I do know that, there's multiple programs. Actually, they responded in discovery to a pretty extensive list. Obviously, there's a pole inspection program. They do line patrols. They in the vegetation management. They have different tiers of, they'll inspect the three-phase portions of the line annually. The single-phase portions get looked at least every 5 to 7 years. There's the substation transformer health program. So there are multiple layers, different programs for different assets that are done. And we did get it in discovery, and happy to share that if you'd like to see that.
Is it your understanding that those inspection programs are primarily O&M or capital in nature? Or could it vary, or do you know?
I can speak to the distribution MRP program and the infrastructure integrity program, which if you want to learn more about it, Guyton Direct Exhibit 5, page 21. That's $273 million in capital costs and $500,000 in O&M installation costs. But that is really focused on replacing the assets, right? Anytime you're going to replace the assets, it's going to be capital. However, the employees that are maybe walking the line, that are doing the inspection, that's going to be part of the distribution O&M spend. And similar programs in transmission if you want to add, but I would just note that as part of the stipulation, we accepted the inclusion of the infrastructure integrity program because we understand that it is important to do condition-based testing, and replacing a product before it fails can significantly reduce outage times, especially when we're looking at lead times on distribution transformers of 3, 4, 5 years or longer. But we had recommended removal of the equipment retrofit program because we felt that that was replacing products that were not end of life, were not failing, were not unsafe, but just simply didn't meet the company's current standards. And we thought that that was not a great use of ratepayer funds.
Okay, and I would generally agree for transmission there. To put in a fairly broad sense for the that type of work that you mentioned would largely be O&M. Now, where I'm not completely clear on the details are where it gets to the smaller components of maintaining a piece of equipment, and not any wholesale replacement of the equipment is going to be capital, but largely the inspections, maintenance, that type of thing will go to O&M.
Okay. All right, maybe just one more here. When there's been a lot of discussion around the ICE calculator, and I think we've gotten into this here in the last little bit. When considering the ICE calculator and how it's used by the company to monetize reliability impacts, do you all believe there's a significant asymmetry of reliability improvements for residential versus non-residential customers in how the ICE calculator kind of monetizes reliability impact or benefit?
Yeah, and I think
I
my
follow up, but I'll go ahead and let you answer.
I think my testimony addresses this, and certainly the witness Guyton rebuts it to a certain extent. I think if you consider a circuit that has 1,000 residential customers and 2 commercial customers and 1 industrial customer, the reliability improvement that's being planned there, every customer is going to receive the same benefit in terms of the number of minutes avoided. Right? It's not like these reliability investments are being specifically installed to benefit C&I customers and leave the residential customers in the dark. And I don't want anyone to come away with that perception. It is a equal opportunity reliability investment that affects the whole circuit. But when you talk about the monetized benefits, just those few C&I customers on that grid will skew the outage costs associated with those customers is extraordinarily high, much higher than the residential customers. So even when you take the number of residential customers multiplied by their small benefit, and you compare that to the number of industrial and commercial customers and multiply it by their giant benefit, you get the distribution that I found, which was, I think, 98% of the monetized reliability benefits accrue to C&I customers. And while I am not recommending that that be used as a method of allocating costs in this proceeding, it is notable that the majority of the costs of those upgrades will get allocated to residential customers. And so I'm just pointing that out, not so much to criticize the existing cost allocation methods, but just to highlight how, as we continue to spend this money to improve reliability on the grid, right, residential customers are bearing the brunt of the costs. No one is getting a reduction to their bill, but C&I customers are realizing the majority of the benefits related to the reduced and avoided outages. And that is one reason why maybe we should pay attention to our pace.
Yeah, and so my little follow-up is, oh, I'm sorry. Were you going to say something, Mr. Lawrence?
Yes, yeah. So one thing that I think needs to be clear as well, with the question you asked, was the benefits customers are receiving in relation to the ICE calculator. But the ICE calculator, of course, as stated earlier, calculates perceived benefits for the residential customers as from their estimate, and then from non-residential customers based on more tangible costs of having to restart their manufacturing process, product loss, things that they're able to measure there. So even on that, within the ICE calculator, there's a little difference in the benefits that are actually being calculated. And then the benefits that are being received, I think, are completely disconnected from the ICE calculator.
Okay, I think I follow. Yep. Mr. Thomas, a quick follow-up. You really kind of got into what I was going to ask about. Has the has the public staff discussed any ways? I know you mentioned cost allocation, and you said, and to paraphrase, you said not touching cost allocation. But my question is about cost allocation, really. So public staff considered any ways to deal with this asymmetry that perhaps would wade into areas of cost allocation?
Certainly, it's been a topic we've discussed, and I think if I subject to check, I think my testimony in the last rate case, I think we actually did make some recommendations around modifying the cost allocation methodology to better align it with the benefits. However, I think when you dig under the hood of the ICE calculator, it gets complicated, right? Because as I think we've discussed in this hearing before, the monetary benefit, let's say there's an outage avoided at a commercial customer and it yields through the ICE calculator $100,000 worth of benefits. The ICE calculator says that all accrues to commercial and industrial customers, but there are tangential, secondary, tertiary benefits that might accrue to, right, that might flow through to residential customers, right? Orders delivered on time, workers paid an hourly wage that don't have to go home, a gas station open when you need it and where you need it that might not have been. So I think just looking at the ICE calculator and saying, oh, well, for reliability benefits, we should allocate 98% of these costs to C&I customers. I just don't know that you can do that with a surety that you are actually capturing that level of benefit. So I don't have a good, clean answer for you for how we fix this. I think certainly our recommendations about pacing and scale and scope and just making sure that we are using the ICE calculator to compare within projects rather than to justify any project that is presented because of the magnitude of these benefits is one way we can do that. But certainly this is a problem I think that is existing outside of North Carolina too, this struggle with how do we quantify these benefits, what's the value of resilience, who's really benefiting, and then how are we allocating these costs.
I appreciate you wading into that hazardous territory with me. All right, that's all I've got.
All right. Excellent timing. It's now 3:19. We're going to take a recess at this time. We will reconvene at 3:29. Thank you. to their seats and close the door to the hearing room. We wouldn't start without you, I can promise you that. But there's one person in this room that's indispensable is our court reporter. The rest of us, hey, that's a different conversation.
And then you have lawyers.
Well, we are now officially reconvened. We will now go to questions on commissioner questions. For the interveners who do have questions, if you, we have, well, Ms. Cressy, you don't have to move to the middle chair. You're close enough.
Thank you, Presiding
Absolutely.
Commissioner. Good afternoon. Just very briefly, Mr. Thomas, following up on some of the cost allocation discussion that you had with Commissioner Gaida, I just want to be clear for the record that the public staff supports the cost of service stipulation entered into between DEC, SIGFR, and CUCA and the public staff.
Yes, and to be clear, I was not right. As I said, not recommending any changes to cost allocation, and we support the cost allocation stipulation.
Okay, and not just support, the public staff is a stipulating party and has signed off on the cost of service stipulation.
Yes.
Thank you. No further questions.
Okay. Environmental Defense Fund. All right. Go right ahead. Go kind of guess the center et al.
Good afternoon, Minash Magru of NCJC et al. I'm going to go back to that question that Councilor Sigfer asked you, and this is in response to Commissioner Gaida's question about has the public staff considered cost allocation as a way of addressing, this issue with the ICE calculator. Do you recall that line of questioning?
Yes.
I think I recall you saying that you had addressed this in testimony that was filed. Was it in the last DEC rate case?
I believe so, subject to check. I think we had identified whenever it was kind of we first started using the ICE calculator. I think this kind of issue, we identified it, and I do not recall if we recommended a change to cost allocation methodology or if we just made an observation that it seemed inequitable. But it was either in the last rate case or the one before that. But I'd have to go back and check testimony.
So it's possible that it's the, I guess, is that the sub 1146?
Yeah, either sub 1146 or sub 1276.
Okay, yeah, because I tried double checking 1276, I just couldn't find it. So I was going to ask you some questions about it. If I okay. So I'm gonna, I think this is a question or line of questions that presiding Commissioner McKissick asked you, and this is specifically, I want to make sure that I get this right. It was your response, and I'm struggling a little bit with the actual question that was asked, but your response essentially was the issue with regards to pacing of these distribution spending projects. If we're thinking about just sort of the general spend and the fit for whether or not these projects are providing benefits to customers. Do you recall that line of questioning?
I think there are, a few. I talked about pacing in general. Yes.
Okay. And again, sort of as this is for purposes of clarifying sort of some of these issues here at a high level. When DEC is proposing distribution spending projects, the approval process for those projects is the rate case, right?
Generally, yeah. I mean, with the MRP projects that DEC includes in the MRP that are approved by the commission, it is my understanding that essentially has pre-approved them in terms of project need. But obviously there are a lot of projects that do not make it into the MRP and that are close to plant in the next rate case, and we can evaluate those for prudence and reasonableness, right? So we'll look back and say, did you really need to do this project? Where the costs incurred prudent. So yeah, that's my understanding, although it gets kind of complex with the non-MRP, the shadow MRP and the MRP projects.
Okay, and I think I heard you say pre-approving need. Could you elaborate on that? And I might have misheard what you said there.
Yeah, I mean, when Duke comes to us with a MRP, the way that we evaluate it often includes determining whether or not this project is necessary. Is the justification for the need for this project sufficient to say, yes, go forth and do this project? And then we look at the reasonableness of the cost estimates. Is this a reasonable estimate? And then in the next proceeding, assuming that they've completed that project, right, we'll look at, well, how much did you actually spend? And did you change the scope significantly? Or did you pretty much complete the project as filed and at the cost you estimated? And so, at that time, I think we can look, and I think we've challenged in some instances whether or not the costs, whether that the project was needed. But we have a whole host of projects to evaluate in the historic period. So I don't know if you think that's good.
Yeah, and to sort of drill down on that, and again, this is really germane to this issue of pacing. When the public staff is reviewing these distribution projects, y'all, as a typical course of practice, y'all sample basically projects. I mean, there's so many projects. Typically, what the public staff is doing is saying, all right, we have X, whatever that number is. It could be hundreds of projects. We're going to take a small sample and say, does this seem prudent? Is that a fair summation of what the public staff does as it does its prudency reviews?
Yeah, I'll start if they have anything to add. I would say, first of all, there's thousands of projects, and yes, we sample projects. We typically look at different areas, different functional areas, and provide some sort of sample. And then when we're reviewing MYRP projects, right, those are not necessarily complete. So in some instances, we will sample those projects. Some instances, there's only a few, so we'll look at all of them. But yeah, it's with the staff we have and the resources we have. I think all of us at the public staff would like to increase our audit rates and would like to be able to evaluate more projects, a higher level of projects, because that's how you find things that are imprudent, right? If you never look at a project, you never know if there was a change order in there that was caused by Duke, but the costs should have been recovered from a contracting dispute. Should have been recovered from the contractor, but instead of being sent to the ratepayer, you can never find that type of stuff out if you don't look at it. So we'd love to be able to have more resources, have more staff to look at this, but we do, I think, the best we can with the people that we have and the time that we have.
And just a couple last questions to sort of to get down on this. When DEC is proposing distribution spending projects, it is typically proposing the project as is. And I'll ask sort of a follow-up question if that first question doesn't make sense.
Commissioner McKissick, sorry to interrupt. Respectfully, notwithstanding council's reference to pacing, I'm still struggling to understand the tether to commissioner questions as the basis for these.
Could you identify
Yeah,
what you're seeking and be specific as to what question was raised?
Again, I think the question that I heard you ask, Presiding Commissioner McKissick, is sort of thinking about SAIDI and SAFE and sort of as these projects are getting proposed, like is the benefit from these projects actually being delivered to customers as a whole? And what I heard public staff witness Jeff Thomas say was basically there is a foundational issue with regards to pacing. And so I think in unpacking that as a issue, which I think would help clarify sort of the general dilemma that the public staff and interveners are faced with regards to the scale of spending that is being proposed. I'm trying to sort of drill down on like what does that review process entail, and ultimately what I want to sort of ask the public staff is when these projects are being proposed, are there alternatives that are being proposed in those projects? And so that's really what I'm trying to get down to.
All right, I'm going to give you a little leeway to get there, but just be mindful of the time limitations and restrictions. And I think a lot of the testimony they provided was pretty clear and unambiguous, but the extent to which you want to clarify or eliminate ambiguity or drill down a little further, I'll give you the latitude to do so.
Thank you. And I genuinely only have like one or two questions. And so I'm going to essentially kind of restate the question I asked or put to Presiding Commissioner McKissick. When proposed distribution spending projects are being included in a rate case application, MYRP, is the company in the process of proposing those projects identifying and putting forward other alternatives that could fit or meet the same need?
So project documentation, which is not filed with the commission, but is provided to us as part of the work papers, is quite extensive. And we had a lot of issues with project documentation in the last PBR. And I think it's got much better at this go round. And so basically every single project in the MRP is backed up by some sort of documentation. For some projects, like distribution projects, it might be a cost estimate. It might be a explanation of the justification for the project, what aspects are being incorporated. For larger projects, for example, I looked at some justifications for facilities, for new facilities in certain cases, and it says, well, we want to build a new building, and we looked at expansion of the old building. We looked at moving across town. So I think there's not always an alternative analysis to an investment, but there often is. And I think we, in our audit of MYRP projects, we try to look at, whether we think an alternative should have been considered and whether we agree with the alternative analysis. Kind of just depends on the project and the case by case scenario.
And this is a lot, unless one of y'all wanted to expound upon that. And last question, to what extent is the company considering non-wires alternatives with its distribution spending projects?
So I know that in the MYRP in general, I think there other witnesses there may be non-wires alternatives. Like I believe there's some kind of microgrid projects on the distribution system that provide some reported reliability benefits. I know in the last PBR there were, but for the most part, the distribution system upgrades such as SOG and capacity and hardening and resilience, the area capacity upgrades, they're fairly, I guess I would call them maybe the kind of the bread and butter of the grid, right? Bigger conductors, bigger transformers. They try to take into account things like rooftop solar and the growth rates of load and adoption of certain new technologies. But to my knowledge, there's not like I don't know if you're talking about like topology management on the distribution system or dynamic line ratings on the distribution system. I'm not familiar with the widespread use of those types of technologies on the distribution system, maybe more on transmission, but generally, I think that we see the justification for the programs as, at least on the distribution level, to be acceptable.
No further questions.
Okay. Brings us to public staff.
Just a few, Commissioner McKissick. Jennifer Harrod on behalf of the public staff, and Mr. Creech and I have somewhat the issues divided up, so he may also have a question or two. Okay. Mr. Williamson, let me ask you a few questions or a couple of questions. Commissioner McKissick asked you about the public staff's reliability PIMs and some of the differences between what the company had proposed. And one of the questions he asked you was about implementation of our zone-based reliability PIM. Can you clarify if that PIM were to be implemented as proposed by the public staff, excuse me, and if Duke were to incur a penalty because the SAIDI or SAFE measurements failed for one of the zones, let's say PD, would the penalties associated with that be flowed to all ratepayers through the rider or just to the ratepayers in that zone? Can you clarify that?
Yes, so the way the payment is set up is if a penalty is incurred, then it flows back through the rider and it would go to all ratepayers.
Okay, thank you. And also you and Commissioner McKissick had some conversation about that zone-based penalty versus just simply taking the existing reliability PIM as proposed by the company and lowering those thresholds so that there were so that it was closer to the existing measurements. And let me just ask you that if that would a lower system-wide threshold eliminate the possibility that one distribution zone could experience worsening reliability while the system average remained overall acceptable?
Right, so but by doing it the zone-based way like we proposed, we would be able to see where those poor performers were. And so the zone-based approach would give us, granularity. We've talked a lot about that today of where those poor performing areas were versus just lowering the overall threshold at a system level would be helpful, but we would still lose that granularity at a zone level.
Okay, and is it your understanding that Duke already has the data to do that, or would it require collecting any new data, or is that data already being collected?
Data is already collected. We received it in discovery in multiple data requests.
Okay, thank you. Mr. Thomas, I'll go right to left. Commissioner Gaida asked you about the possibility of, or asked you, and he had a conversation about a transmission line extension plan. So just for clarity of the record, could you speak to the timing of how that plan could be, developed and implemented, and what the procedural posture would be? And in other words, is that something that would need to happen through this rate case, or could the company work with the public staff to develop a reasonable plan and propose it to the commission, following this rate case?
Yes, I think that the commission could direct the public staff for DC to develop that and submit that at a later time. But I think ultimately the recommendations that our large load panel made regarding our large load tariff and the modifications to the service regulations, it's not impacted by maybe some fine tuning or development of a line extension plan. And I believe those witnesses were quite clear that we are recommending that those our tariffs be approved in this proceeding. But the applicability of, our tariff requires some immediate payments about required facilities, applicable to facilities over 50 megawatts. So certainly I think there's space after this proceeding, potentially before the next proceeding, next rate case, or in an entirely separate proceeding, to more clearly define and develop a line extension plan for transmission customers that might not be affected by less than 50 megawatts and not subject to our large load tariff. But certainly we don't believe that the large load tariff should be delayed or held up by the development of a line extension plan. We still think that should be approved in this proceeding.
Okay, thank you. Mr. Lawrence, Commissioner McKissick had a question for the panel about using whether the company ought to, well, let me rephrase that. Whether there are other criteria other than the ICE calculator for selecting transmission projects. And I wondered if you could comment on what role the availability of operational benefits such as O&M savings could play in selecting transmission or distribution projects.
Yes, so through that response, I've mentioned a few reasons why the ICE calculator may not be, or the cost benefit analysis in general may not be a great measure just because of the need for the project. However, even in those instances, and when projects are being done because they are beneficial to ratepayers, we need to understand the full cost that ratepayers are paying now, cost that they will pay later. And a big part of that is the maintenance being performed, the benefits that they have on those, the equipment that's there currently. Without that information, and I speak through it in my testimony, You can't quantify the full benefit the customers will receive. If you don't know how much you're spending now, there's no way to know what you're going to be, what a customer might say, how it's going to impact the bill. And there are, I think in distribution, for example, there are estimates of O&M, which for transmission, there have been no attempts to even estimate those O&M benefits that customers would receive because they track it on a program level basis that doesn't give the granularity. However, I believe there are opportunities there for some, at a minimum, some reasonable estimates to be made and applied.
All right. And would that be a way that that would help the company to select projects that would be beneficial to customers?
Yes, it would.
I just want to reconfirm with this panel, y'all support the partial stipulation with the company in this proceeding, correct?
Yes. Yeah.
Commissioner McKissick, no further questions from the public staff.
All right. Well, since there are no further questions, public staff, this panel is released at this time.
Thank you.
Mr. McKissick, we have conferred with the other parties, and for efficiency, we would propose to put up our witnesses, Jay Lucas and Roxy McCullough, as a panel. That's acceptable to the committee.
That is acceptable.
And we will call them.
Absolutely.
So the public staff would now call witnesses McCullough and Lucas. Please.
Lucas here. Give you a minute to get situated. And if you could put your left hand on the Bible, raise your right hand. Do you solemnly swear that the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay, good afternoon.
Good afternoon.
Witness McCullough, would you please state your name, business address, and current position for the record?
My name is Roxy McCullough. My business address is 8625 Farmington Cemetery Road, Pleasant Plains, Illinois. I work for William Dunkel and Associates as a consultant and expert witness, focusing mainly on depreciation regulatory cases.
And in this instance, you're testifying on behalf of the public staff?
I am, yes.
Okay, very good. And Mr. Lucas, would you please state your name, business address, and current position for the record?
My name is Jay Lucas. My business address is 430 North Salisbury Street in Raleigh, North Carolina. And I'm the manager of rates and energy services for the public staff's energy division.
And Ms. McCullough, on May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 30 pages, 5 exhibits, and 1 appendix?
Yes.
And did your testimony contain confidential information?
No, it did not.
On June 16th, 2026, did you prepare and cause to be pre-filed an errata with corrections to your pre-filed Exhibit 1?
Yes.
Do you have any additional corrections to your pre-filed direct testimony or exhibits?
No, I do not.
If I were to ask you the same questions in your pre-filed direct testimony today while appearing on the witness stand, would your answers be the same?
Yes, they would.
Did you prepare and cause to be pre-filed on July 6th, 2026, the summary of your testimony, docket number E-7, sub 1329A?
Yes.
Turning to you, Mr. Lucas, on May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 19 pages, 5 exhibits, and 1 appendix?
Yes.
Did your testimony contain confidential information?
Yes.
On July 2nd, 2026, did you prepare and cause to be pre-filed an errata with corrections to your pre-filed Exhibit 3?
Yes.
And do you have any additional corrections to your pre-filed direct testimony? Excuse me.
No.
If I were to ask you the same questions in your corrected pre-filed testimony today while appearing on the witness stand, would your answers be the same?
Yes.
Did you prepare and cause to be pre-filed on July 6th, 2026, a summary of your testimony in docket number E7 sub 1329A?
Yes.
Presiding Commissioner, at this time, I move that the following testimony be entered into the record as if given orally from the stand, and that the following exhibits be entered into evidence as pre-marked. The pre-filed testimony of witness McCullough, consisting of 30 pages, 5 exhibits as corrected, and 1 appendix. The pre-filed summary of the testimony of Ms. McCullough. The pre-filed testimony of Mr. Lucas, consisting of 19 pages, 5 exhibits as corrected, and 1 appendix, and the pre-filed summary of the testimony of Mr. Lucas.
Without objection, your motion is allowed.
Thank you. The witnesses are available for cross-examination and commission questions.
I see that Sigfer has reserved time.
Thank you. Good afternoon. Just very briefly, I was wondering if you could explain for those of us who are not CPAs, what the remaining areas of disagreement are after the partial stipulation that was filed between DEC and the public staff.
All right, I can start. Witness McCullough can add in my testimony, none of the items were covered in the partial stipulation.
And Ms. McCullough?
Same here.
Okay. And again, for those of us who are not CPAs, can you explain the areas of disagreement between the public staff and DEC?
I'll start. My area of focus was the decommissioning study. I sought to remove some asbestos removal costs that DEC wanted to include in the decommissioning study. Also wanted to remove the contingency costs that Duke wanted to add in the decommissioning study.
Thank you. Ms. McCullough?
As compared to the study as filed attached to Spanos Exhibit 1, I had difference of opinion with regards to the life of account 368 and the life of account 369. And then I had a difference of opinion on the future net salvage estimates for account 362, account 366, and account 367.
Thank you. And have you all had an opportunity to review the rebuttal testimony of DEC witness John Spanos?
Yes.
Yes.
Do you have anything to say in response to his testimony?
Yeah. Okay, I'll go first. Yeah. When I read his rebuttal testimony, he seems to misrepresent my proposals. He seems to look at regarding the future net salvage proposal. He claims that I'm proposing a future net salvage accrual that is the same or similar to the recent average expense, which is incorrect. He looks at my table 6, which clearly shows that I'm not expensing that amount, nor am I proposing an under recovery. And his rebuttal seems to start with that false representation of my testimony and then rebuts that as far as the future net salvage. For the 2 accounts where I propose a different life, for the account 368, he points to the fact that the curve I propose shows a minor percentage surviving till about, he says, almost 100 years. If you look at his Exhibit 1 around page 254 and 257, you'll show that a small percentage actually has lived to almost 100 years. With regard to my life proposal for account 369, he makes a claim that since approximately 70% of the amount is still in service around the age 60 or 64, that the data is inconclusive. I'd say that is a good data point to consider, that about 70% has lived to 60 years. So I'd say that's a broad overview of my response to his rebuttal.
Thank you. Mr. Lucas?
I don't have anything to add.
Okay, thank you. No further questions.
All right, now I'm not seeing any other intervener who is reserved time to cross-examine this witness. Would that be a correct assumption? So we will go back for redirect.
Thank y'all. Hello again. You had a question from Ms. Kress just now relating to the differences in between Duke and the public staff and your review of the rebuttal testimony in this proceeding. We kind of have an odd scenario here a little bit, don't we, where on direct, witness Spanis testified, and then on rebuttal, witness Spanis and Kopp testified, but we also had witness Bowman change Duke's recommendation to instead of increasing depreciation expense and going up to 20% on the decommissioning contingency, Duke's current proposal is to keep depreciation rates the same and effectively, which also means that the stipulated, this was not a litigated issue, but the stipulated decommissioning number of 10%, it would continue on. Is that correct? And can you all elaborate on that?
Yes, I can start off. If we kept the same decommissioning procedures that we agreed to in the previous case, depreciation costs would be lower. The contingency would remain at 10% that we settled on. There's another aspect, indirect costs, where if a power plant's decommissioned, the contractor decommissioning the plant will have some incidentals like construction trailers, could be temporary roads, temporary utilities, et cetera, to the site. That would stay at 5% compared to what the 11% that Duke requested in this case. I haven't personally seen the cost shift, but my concern is that if we keep depreciation costs low in this case, that power plants and all the equipment's still going to depreciate. I'm concerned those costs will accumulate and it might push down rates somewhat in this case. It might create higher rates than we would have found in future rate cases.
I have nothing to add.
Right. And then following up on that, there remains a disagreement on asbestos. Is that correct as well?
Yes, that's correct.
Okay. And that's on 2 plants. Is that correct? You're not talking about all the plants.
No, that's just 2 out of the 43 plants. Looked at all of them. Some of the plants are older hydro plants, older coal plants, and it's justified those plants would have asbestos. And Duke did not include asbestos removal on the much newer plants, like it should not have. There are 2 plants, the Bad Creek and Bridgewater plants, where Duke built or made improvements to long after it was well known that asbestos was a danger. And I brought this issue up 3 years ago in the previous case, and Duke acknowledges that. It still hasn't tested. It just still uses conjecture to think there might be asbestos at those 2 plants.
All right. And witness McCullough, you indicated your concerns about when asked about the rebuttal testimony of witness Spanos, you indicated your concern about the way things were stated there. As I've looked at this more, depreciation, I thought it was a fairly straightforward scenario, but it turns out to be one of the most interesting aspects of this entire case. I don't know if everybody will agree, but can you help the commission understand why there's a disagreement between you and Mr. Spanos about how you see things? I mean, obviously he said that he's doing a traditional method. He said that he's following all the text, but you say you're following all the text. And you both talk a lot about informed judgment. That's kind of like the grand term of depreciation.
Right. We both reviewed the historic data and applied informed judgment to arrive at our proposals. I think at even one point, I can't recall where he says this in rebuttal, something about we interpreted the data different. And that could be, that's what, yeah, informed judgment. I would call that our informed judgment application. The real concern I had with his rebuttal was he's claiming that my net salvage proposal is an expense or it's the same and similar as the current expense level. And my table 6 shows obviously is not, you know, it would, the last column on my table 6 would be a 1 if it was the same, but it's not. So the reason I put that table in there is anticipation of any rebuttal claim that my proposal will under recover. And the point of showing that comparison is to show that not only does my proposal collect enough to cover what we expect to be the expenses in the very near future, but it also builds a reserve for any increases expense in the future.
And just explain as well for the commission in terms of the disagreement, why is there a disagreement in this instance? I mean, why would the public staff, Duke is now indicating, notwithstanding the testimony in rebuttal, the points raised in rebuttal by witness Spanos and witness Kopp, you know, the Duke's position now is to keep, through witness Bowman, is to keep depreciation rates the same. Why would the public staff say, hey, you know, depreciation rates are going up? Ratepayers ought to pay for it.
I'll defer that to public staff.
Yes, like I mentioned, equipment, power plants, transformers are still going to depreciate. They're going to wear out and reach the end of their service lives. Public staff is concerned that if Duke continues to accumulate that depreciation without including in customer rates, customers could see lower rates for the next 2 or 3 years, but those depreciating assets and those depreciation costs are going to catch up to them. It has to be made up in a future rate case. We don't want that to happen.
And one of the main issues between the public staff and Duke on rebuttal, and this is witness Kopp. Witness Kopp suggests that going down on decommissioning, I guess in this instance, going from 10% stipulated down to 0, like the public staff is recommending, would create intergenerational issues and it would create a deferred financial burden. Do you agree that, you know, that this creates a deferred financial burden?
No, I'm not throwing out decommissioning costs. The contractor that did the study, Burns and McDonnell, did a decommissioning study with decommissioning costs, came up with estimates. I didn't disagree with those except for the 2 minor items on asbestos. Duke also adds 11% for indirect costs. I agree with that. So Duke should put decommissioning costs into depreciation rates. Where I disagree is on top of all that, on top of all its estimates, Duke wants to add 20% contingency and start charging customers right away for this assumption that its estimates are wrong. Duke added 20% contingency to all 43 power plants that it included in the study. I don't think that's fair to charge customers now for something that might not happen.
All right. And just one final piece. We've got there are issues of.
Presiding
Yeah, go ahead.
Commissioner, I would respectfully object at this point. This is it's starting to feel more like direct examination versus redirect on any of Ms. Kress's questions.
I would just say we are in a slightly odd scenario where we had Duke's witnesses, they were consultants.
Yes.
But they seemed to be arguing for positions that were kind of not the current. We
I
had
know.
witness Kopp who was testifying seemingly for a 20% decommissioning contingency. The commission asked for a late filed exhibit, I believe, on that. And I'm trying to make sense of the fact that where we are in terms of the disagreement between the public staff and Duke. But
If you could focus your questions to that narrow issue. Yeah. And we'll give you a little leeway, but otherwise, you know, it's getting late in the day, and I think that there's validity that in what's been articulated and expressed, even though it wasn't made as a motion at that time.
Well, I'll just, let me just say at this stage then that, Mr. Lucas, can you just explain, please, the rationale for the public staff's position on the 0% decommissioning contingency as opposed to Duke's current position on the stipulated, presumably the stipulated?
Yeah, I can give an example. Duke plans to retire its Bad Creek plant in the year 2077, over 50 years from now. It wants to charge customers as a result of this rate case, begin charging them now for decommissioning. And I don't disagree with that. Customers today are using that plant and they should pay for the decommissioning costs. What I disagree with is Duke's assumption that its estimate is wrong and it has to add 20%. And part of its justification is saying, well, there could be environmental contamination. Duke already built in some environmental contamination costs in its cost estimate. And I don't disagree with some of those environmental contamination or remediation costs. Either Duke's double counting by saying we need to add contingency for more environmental contamination, or Duke's claiming that it has created excessive environmental contamination. And in that case, I don't believe it's the customer's fault. Customers should not be paying for excess contamination.
Thank you. No more questions.
All right, we're now going to move to a few questions from our commission staff, as well as other commission or questions. Mr. Lucas, in your qualifications, it stated that you assisted in asbestos removal while serving in the Air Force. Did your experience with these removals inform your recommendations to exclude asbestos removal costs? And if so, please elaborate.
Yes, I started with those asbestos removal projects in 1986. We had a team of people that had already been doing that for years. So it didn't start when I showed up. And everybody in the industry knew years before that there was no such thing as good asbestos. I know Duke says, well, there wasn't a complete ban until 1989. People knew many years before that asbestos was bad. And I cite in my testimony a National Institute of Occupational Safety and Health study from 1976, very conclusive that asbestos was a threat. It did not find any safe levels of asbestos fibers in the air. Based upon that study and based upon my experience of having removed asbestos, Duke should have known well before 1980 that there was no such thing as good asbestos, and it should not have been included in any equipment that Duke built or bought.
All right. Now, in your testimony, you discussed in 1976, I'm going to refer to it as NOSH, N-I-O-S-H.
Yeah.
Asbestos standard and other significant milestones in the recognition of asbestos hazards. With this background in mind, what would a reasonable utility manager have known about asbestos hazards and potential future liabilities at the time the Bad Creek facility was designated, designed, and licensed?
Yeah, anyone on Duke's staff that was responsible for building facilities or ordering equipment should know well that asbestos was a problem. It was dangerous. There were studies, lawsuits all throughout the 1970s that should have informed people who were in the industry, order equipment, and should have been aware. Duke's statements are a lot of conjecture. They're saying it's likely to have asbestos. It's considered to have asbestos. Like I said, I brought this up 3 years ago in the previous rate case, and Duke has not gone in and confirmed what I claimed 3 years ago. In the previous decommissioning study in 2022, Duke visited, Burns and McDonnell visited 16 sites, did inspections, And just this latest study in 2025, Burns McDonald staff only went to one plant, and that was the Lincoln County CT-17. So they didn't even try to look at any of the asbestos that I pointed out 3 years ago.
Did you follow up with them in connection with that?
Well, I brought that up in a data request. Give me a moment. This is my exhibit number 4. It's Duke's response to our data request 99-7. Excuse me, I've got the wrong number here.
Take your time.
It's excuse me, my exhibit number 2. This is Duke's response to our DR 152-2. And asked, please justify why the Bad Creek plant and the Bridgewater plant have asbestos. And the first sentence in Duke's response is, the public staff has requested similar explanations for these 2 facilities in prior filings. And Duke's correct. It did not go back and test for asbestos. It says we assumed the building had asbestos. It's likely to contain asbestos. We assumed the powerhouse contains asbestos. And it also goes on to say that at the Bridgewater plant, it cut out equipment and relocated it and said that plant, that equipment could have contained asbestos. I think it was imprudent for the company to have equipment that it suspects contain asbestos to cut it out and move it without testing and confirming. I think that's an imprudent action, and Duke should have tested. And if that equipment had asbestos, Duke should have removed it. It should not include those costs in this rate case.
Thank you. Now, these additional questions go to decommissioning contingency costs. And your recommendation to remove decommissioning contingency costs. For clarity, following the line of questioning by Mr. Creech, does the public staff maintain their original position to set contingency at 0% for coal decommissionings? Do you believe that's appropriate?
For all decommissioning of all 43 plants, we want contingency set at 0. Duke can claim its estimated decommissioning costs, and it can also claim its 11% adder for indirects, but we don't want an extra 20% added on top of that. Customers should not pay for a cost that may never materialize.
And how does Duke's withdrawal of its request to adjust annualized depreciation expenses, effectively maintaining the 10% decommissioning contingency, alter your recommended adjustment amounts compared to the original $90 million?
We were working on the math on that to change the decommissioning. In the previous rate case, we settled on a 10% decommissioning, contingency adder, and the commission agreed and put that in the order. We can go back and do the math and say, okay, if we went back from Duke's 20% decommissioning and up from my 0, we met at 10%. We are in the process of doing that math, and we can get that to you.
Okay. Have you reviewed recently completed decommissionings of Duke's generating facilities? And if so, how did the final decommissioning cost compare to early estimates?
I've done partial. I've looked at the indirect costs, and Duke is justified in the 10% adder. I have not gone back and looked at the prior studies. A lot of the power plants were not torn down in recent history. Most of these power plants that have been torn down in the past were torn down years ago. I don't believe there's been much demolition in the past few years.
Okay. Now, if actual cost for plant decommissioning comes in below the estimate plus contingency, what is the rate-making treatment of this difference? Are ratepayers provided a symmetrical benefit?
Decommissioning costs help lower rate base, so customers would see a benefit from lower rate base from some of the decommissioning costs. This might be a question better for our accounting division. As far as how these decommissioning costs flow through into final rates for customers. I can't give you a complete answer right now.
Okay. We'll defer this then to the another panel. Is this, if this contingency is not allowed, as you recommend, what is the existing rate-making mechanism for Duke to recover these costs to the extent the commission were to find them to be prudently incurred?
If the cost estimate, the base cost estimates plus the 11% are accurate, Duke would be made whole for its costs whenever it tears down that power plant. There would not have to be any additional rate-making proceeding. I can go on to say if somehow costs are more, then my recommendation, Duke can still collect those costs in a future rate case.
In Lucas Exhibit 4, Duke stated that uncertainty surrounding environmental contamination, groundwater quality, and hazardous materials contribute to the risk accounted for in contingency. Does the 2025 decommissioning study reflect any differentiation in these risks among the itemized projects?
I can give an example. Like at the Blues Creek plant, Burns McDonnell puts in lots of itemized costs. Demolishing the boiler, the steam turbine, the precipitators, the scrubbers, the smokestacks, and it goes on, has the demolition of the foundation, and it also has other costs. It has transformer oil disposal, soil remediation beneath the fuel tank, underground storage tank remediation. Burns McDonnell does include these costs, like a soil remediation beneath the fuel tank. The study allowed $48,000 for that. I have no problem with minor remediation of some environmental contamination. Somebody might have spilled a little fuel oil along the way, but what Duke is claiming is that there's much more environmental contamination beyond the itemized list. So it's adding 20% just in case there's additional contamination. And if there is, that's not the customer's fault. If Duke significantly contaminated the environment, it should pick up those costs and not pass them on to customers.
Thank you for your testimony. I think we pretty much, let me look over here. Go ahead, Commissioner Tucker.
Mr. Lucas, was it, refresh my memory if you would, please, was it Mr. Kopp from Duke that was in charge of the demolition of the plants?
Well, he's the one who filed rebuttal he works for Burns McDonnell. He filed rebuttal on Duke's behalf.
All I remember is he sat on the end there, but somebody was an employee of Duke and said that had a budget of $500 million for decommissioning plants and had a team of people. And then you stated that you haven't seen much demolition go on. Am I confused in that?
I'm not sure. If Duke might have torn something down the past few years, they don't have to tell the public staff when they tear a plant down. They can let it sit there for years and tear it down, or they can tear it down right away the same day they turn the switch off. I have worked in my work on coal ash. I've seen Duke tear down a lot of the old coal plants. A lot of those were demolished years ago. Duke may have demolished something in the past few years. I don't know if Duke can provide a list of what it's done in the past 5 years.
Well, I was just trying to tie what you said to what I thought I heard. So, okay, thank you, sir. That's all the question I have, sir.
Commissioner Guida. All right. Opportunity for questions on commissioner questions.
No questions.
All right, if I may just quickly here, Asbestos. It sounded like, Mr. Lucas, that asbestos was your sole focus for, for a long, long time. But you're I mean, for the last days, barreling down on this particular issue, but you're not recommending that the commission get rid of the company being able to recover for environmental cost in general. This is just for two plants.
There's two plants, and there, like I said, there are a lot of older coal plants and older hydro plants that could have asbestos. It would have been reasonable. It was before asbestos was a known danger. So I don't fault Duke for including asbestos removal costs for those older plants.
So just to clarify, it may be in the other ones, but you're only recommending taking that out of two.
Yeah, if Duke had asbestos in those two plants, Bridgewater and Bad Creek, it was imprudent and it should not be there, and they should not recover costs for it.
All right, and then one of the commission questions related to the contingency and basically planning for the future. If let's say if, and we talked earlier about how the expressed concern by a witness cop about intergenerational issues and deferred liabilities. But even if Duke is correct, let's say Duke's position is correct, they're accounting for, they would provide for 10% contingency, but the remaining amount that for which Duke has estimates that include indirect cost, those are being accounted for in rates, are they not?
Yeah, and the rates Duke's customers are paying today are based upon the previous case in which Duke did get a 10% contingency for decommissioning plus 5% for indirects.
And just also in terms of contingencies, one aspect that I think is interesting here is that the salvage value that we're dealing with in these reports may be in nominal dollars, but for depreciation accounting purposes, those numbers actually are grossed up. Is that correct, Witness McCullough?
In the calculation of the depreciation rates, the decommissioning costs then are inflated to the projected retirement year. Yes.
All right. And then I guess just finally, if the figures are grossed up for inflation, and if there are indirect costs in this scenario, but is the public staff's concern still that ratepayers will be charged for, as part of a decommissioning contingency, ratepayers will be charged for unforeseen, unknown
These are
expenses?
That's correct. Those costs are unforeseen and unknown, and they may never happen.
But you do believe that the depreciation expense in general is going up, which is why the public staff has, and Witness McCullough has recommended the rates that we have. Is that correct?
There were many accounts where the Spanos Exhibit 1 did increase the depreciation rates that I did not object to, that they seemed reasonable. Yes.
All right, very good. All right, I think that is it. Thank you so much.
Okay. Well, we've come to an end with you all. We thank you for your testimony. And Mr. Lucas, I don't think you're coming back, are you? Are you on a part of another panel?
Back to large load panel. We'll see.
Okay, all right. Very good. That's right. You're refreshing my recollections. Thank you very much.
Thank you.
Thank you.
Go right ahead.
Ann Keyworth for the public staff. The public staff now calls Dustin Metz to the stand.
If you could put your left hand on the Bible and raise your right hand. You solemnly swear the testimony you're about providing this proceeding will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you.
Mr. Metz, would you please state your name, business address, and current position for the record?
My name is Dustin Metz. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm the director of the Public Staff's Energy Division.
On May 29th, 2026, did you prepare and cause to be pre-filed direct testimony in this docket consisting of 17 pages and one appendix?
Yes.
Did your testimony contain confidential information?
Yes.
Do you have any corrections to make to your pre-filed direct testimony?
No.
If I were to ask you the same questions in your pre-filed direct testimony today while appearing on the witness stand, would your answers be the same?
Yes.
Did you prepare and cause to be pre-filed on July 6th, 2026, a summary of your testimony in docket number E7 sub 1329A?
Yes.
Have you reviewed the agreement and stipulation of partial settlement between DEC and the public staff filed in this docket on July 2nd, 2026?
Yes. I support stipulation as a negotiated compromise as a give and take between the public staff and DEC.
Thank you. Presiding Commissioner McKissick, at this time I move that the pre-filed direct testimony of Mr. Metz consisting of 17 pages and one appendix and the pre-filed summary of the testimony of Mr. Metz be entered in the record as if given orally from the stand at the appropriate time.
This is the appropriate time.
I agree.
Without objection, your motion is allowed.
Thank you. This witness is available for cross-examination and commission questions.
All right, I see that Sigfer has reserved a few minutes.
Yes, thank you, Presiding Commissioner McKissick. Mr. Metz, I'm going to have lots of questions for you when you return on your policy panel, but for now, I just want to ask a few questions about one topic, and that is the TCA stipulation. Is there anywhere in Chapter 62 that you can point me to that authorizes the stipulated adjustment agreed to between the company and the public staff?
I'm going to object on the basis that this witness is not a lawyer who can make legal conclusions.
And respectfully, I think, Presiding Commissioner McKissick, it is up to the witness to answer if he can. And understanding that he's not a lawyer, he is very familiar with Chapter 62 and the statutes within which this commission makes decisions.
I understand that he's certainly not a lawyer, not able to express a legal opinion. At the same time, I would rather have that question addressed to somebody who can answer it more effectively and thoughtfully. So I'm going to go ahead and sustain the objection.
Mr. Metz, are you aware of any similar revenue requirement adjustments that have been made in the TCA stipulation in any proceeding other than DEC's last general rate case, the sub 1276 proceeding?
I'm just thinking here for a second. As I sit here right now, I can't think of any.
And so is it fair to say that the only precedent you are aware of for such an adjustment is the last DEC and DEP general rate case, E7 sub 1276 and E2 sub 1300?
So my time with the public staff, a little over 10 years. So I cannot with perfect memory recall everything that has happened before my time. But based upon my time here is my general understanding in relation to DEC and DEP. This would be one method that is used as a pro forma adjustment.
But you're not aware, as you sit here today, of any other examples in which the commission has made a similar revenue requirement adjustment between two affiliated utilities?
Well, I'll pause there for a second, and I'm getting a little bit over my skis here. I'm trying to think of labor and labor allocations. I do believe that there are overall costs at the Duke Energy level that are which allocated to holding companies or the respective utility companies.
Okay. Would you agree, subject to check, that this issue of whether the commission has statutory authority to allow a revenue requirement adjustment such as that in the TCA stipulation was not decided on the merits by the North Carolina Supreme Court?
I can't recall the specifics of what the Supreme Court ruled on.
Thank you. The commission has already taken judicial notice of the Supreme Court's opinion in the appeal that followed the last two general rate cases. Please let the record reflect that Sigfer objects to the TCA stipulation and will be briefing this issue in its entirety. Thank you.
It's duly noted for purposes of the record. It looks like CUCA reserved a few minutes.
Thank you, Presiding Commissioner
Sure.
McKissick. Christopher Dodd on behalf of CUCA. Good afternoon. I'd like to stick with the TCA just for a few more minutes here. And so just to kind of level set, this is a pro forma adjustment to increase DEC's revenue requirement and lower DEP's revenue requirement to account for an imbalance in transmission traffic from DEP to DEC, correct?
Yes, because this helps address the inequity concerns that we brought this commission in multiple dockets before. So to try to give context to some of the items that go into this is saying, okay, we have seen increasing energy flows from Duke Energy Progress over to Duke Energy Carolinas. That's outstanding. Both utilities have relative lower rates, except when we talk about transmission, it's just one item. Again, I'm not trying to beat a dead horse. I've said this multiple times from this commission. Transmission is one of the levers here. So DEP customers are being asked to pay for 100% of the transmission assets, even though we're flowing, I can't remember the exact numbers, somewhere between 5 to 10% of the energy over to Duke Energy Carolina customers. What does that mean? In part, that would mean that Duke Energy Carolinas is lowering its operation of its plants. So Duke Energy Carolinas are saving on the reduced, in theory, are saving on the reduced O&M for their plants that are in base rates. So the TCA is one of the levers to account for that inequity issue. In order to balance why DEC has lower rates, they should essentially, we use this pro forma as a proxy to account for the ongoing transmission cost and the O&M cost of the transmission system.
But would you agree that this adjustment involves no actual payment by DEC to DEP?
That is my general understanding, but the overall accountants would need to speak in more details of how it goes to the overall, the rates between, not the rates, but the overall books of the two companies.
Did you hear Ms. Bateman for DEC confirm on cross-examination that there's no accounting entry associated with this adjustment?
I believe Ms. Bateman had a discussion on that. I can't remember the specifics.
And there's no change to dispatch costs as a result of the adjustment?
There's no change to the dispatch costs because of the adjustment.
And so under the settlement stipulation, which, this is a part, DEC customers would pay rates reflecting a $31 million expense that DEC does not actually incur, has never incurred, and will never remit to anyone, correct?
Well, I think that is correct. But with the qualifiers, as stated before, DEC rates are artificially suppressed because they're be able to get the subsidized energy that's coming from Duke Energy Progress customers.
Wasn't that an outgrowth of the Duke and Progress Energy merger in 2012?
Is my understanding, that was before my time with the public staff as a function of the joint dispatch agreement. And as I believe I provided testimony in front of this commission on the business combination between DEC and DEP, is my general understanding is that when the JDA was created, it was not intended to be at the scale of magnitude of transfers that are occurring between DEP and DEC. Also, in addition, it was my understanding, as I testified again, in the business combination between the utilities, I believe that they were expecting a combination of the two utilities much sooner than over a decade later.
So changing gears slightly, still within the TCA, was any cost study performed on the amount of adjustment that should take place here?
Don't quite understand the question. If you can repeat, please.
So as part of the stipulation with the public staff and DEC, they've set the TCA amount as roughly $31.2 million. My question is, was a cost study performed to show that $31.2 million is the correct number, or is based on costs that are actually incurred?
Yes, those costs are actually incurred because you're using the FERC open access transmission tariff, which actually uses Duke Energy Progress's actual costs. And part of this adjustment of this rate case, we also included the additional plant costs that were part of the capital cutoff date. So I would say, yes, they are known and measurable.
There's no FERC tariff obligation to pay those amounts, correct?
Can't ask a question to council, but I'm trying to understand, are you asking the question if NC retail is obligated to pay wholesale rates, or if a FERC wholesale customer is obligated to pay for wheeling transmission through the OAT rate?
Are DEC ratepayers subject to the FERC OATT rate?
They could be in part, to the extent that, yeah, they could be in part.
Could you expound on that?
Well, to the extent that if someone uses a Duke Energy Carolina's system, then yes, Duke Energy Carolinas would receive that revenue, if you would, from the utilization of its transmission system.
No DEC customer pays rates under the FERC tariff, correct?
DEC has wholesale customers, so I would believe, yes, certain DEC customers would be paying the FERC OAT rate.
Do DEC retail customers take service pursuant to the OATT rate?
My understanding would be no, because those overall costs are in their base rates.
And just to clarify, is the TCA included under base rates? I believe that's what your testimony says.
To the extent that the overall TCA calculation is included in the revenue requirement, then yes, they would be a function of their base rates.
No further questions.
Okay. The Environmental Defense Fund? No questions? Okay. In which time we'll go back for redirect.
No redirect, thank you.
All right. I know I don't have any questions from commission staff, but let me see if there are any questions from commissioners. No questions from commissioners. So at this point, sir, you are, I won't say released unconditionally, but released from speaking individually as it relates to the issue that's before us at this time. Thank you. You may call the next panel.
Thank you, Commissioner McKissick. The public staff now calls Caleb Hill and Dr. Leah Weaver, appearing as the renewables panel, to the stand.
And I would just remind you that you're both under oath for affirmation.
Mr. Hill, would you please state your name, business address, and current position for the record?
Good afternoon, Caleb Hill, engineer with the Public Staff Energy Division. My work address is 430 North Salisbury Street, Raleigh, North Carolina.
And Dr. Weaver, would you do the same?
My name is Leah Weaver. My business address is 430 North Salisbury Street in Raleigh, North Carolina, and I'm an engineer with the Energy Division of the Public Staff.
As a panel on May 29th, 2026, did you both prepare and cause to be pre-filed direct joint testimony in this docket consisting of 45 pages, 22 exhibits, and 2 appendices?
Yes, we did.
Did your testimony contain confidential information?
Yes, it did.
Yes.
On July 2nd, 2026, did you both prepare and cause to be pre-filed an errata and corrections to your pre-filed joint direct testimony?
Yes.
Yes.
Do you have any additional corrections to your pre-filed direct joint testimony or exhibits?
No.
No.
And if I were to ask you the same questions in your corrected pre-filed joint direct testimony today while appearing at the witness stand, would your answers be the same?
Yes.
Yes.
Did you both prepare and cause to be pre-filed on July 6, 2026, a summary of your joint testimony in docket number E7 sub 1329A?
Yes.
Yes.
Have you reviewed the agreement and stipulation of partial settlement between DEC and the public staff filed in this docket on July 2nd, 2026?
Yes.
Yes.
And do you support that stipulation?
Yes, I support the stipulation as a negotiated compromise and give and take between the public staff and DEC.
And I also support the stipulation as a give and take between the public staff and DEC.
Thank you. Presiding Commissioner McKissick, at this time, I move that the corrected pre-filed joint testimony of Mr. Hill and Dr. Weaver, consisting of 45 pages and 2 appendices, the 22 exhibits as originally filed, and the pre-filed summary of the joint testimony of Mr. Hill and Dr. Weaver be entered into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you. And this panel is available for cross-examination and commission questions.
Thank you. Good afternoon, Mr. Hill. I hope you're feeling better since the last time I saw you. Dr. Weaver, I think the last time I saw you was this morning, but honestly, all my days are running together at this point. I just have a few questions. We testify in part about the MYRP framework and how ratepayers prepay for specific projects that may or may not get delayed or canceled. Is that right?
That's correct.
And sometimes ratepayers prepay for specific projects that do in fact get delayed or canceled. Is that right?
Yes, that's been our experience so far with MYRP 1.
And did you also evaluate cost overruns for the projects that were within the scope of your panel's testimony?
Yeah, I would say we did.
Can you talk to us a little bit about the cost overruns experienced in the Beaver Dam and Baxter Creek solar projects?
Just give me 1 second. So our exhibit 1 is a summary of some of this information about the MYRP 1 projects. And so if you look at exhibit 1, you can see that for Baxter Creek, there was a change of about 15% between the original estimate, and this is based on the fourth quarter 2025 estimate, and a 46% change for Beaver Dam between those two estimates.
And was the primary cause of those cost overruns associated with the bankruptcy of the EPC?
I believe that was one of the principal causes of the change in cost.
Okay. And is it fair to say that the average delay for completion of hydro projects is 10.5 months?
Can you remind me where that is in our testimony?
And I can, not sure if it might be faster if you find it first, though.
That sounds correct. I just want to verify.
Page 16.
Yes, 10.5 months.
Thank you. Have you had an opportunity to review the pre-filed direct testimony of SIG for witness Brian Collins?
Yes, I've reviewed it, but I appreciate specific details.
Have you had an opportunity specifically to review the project level clawback mechanism for battery energy storage projects that witness Collins proposes in his testimony?
I believe I've reviewed that portion of his testimony.
Do you or the public staff have any thoughts or reactions in response to that proposal?
Sure. So the public staff shares Mr. Collins's concern about the related to the increases in costs in battery projects, especially considering that battery generation doesn't have the same CPCN requirements as other generation. Our approach to that, or our response to that, was in our DEP testimony. We've proposed a RFP for standalone battery storage to try to help mitigate on the front end to ensure that the battery projects that are being built are the most cost effective, especially on an open market. So that's something that we would, appreciate seeing in DEC as well, even though we didn't originally make that recommendation. Specifically with regards to Mr. Collins' recommendations, the public staff isn't necessarily opposed to that approach, but I think we would require some more internal discussion to be able to give a more concrete position on that issue.
Thank you. And I just want to ask one follow-up. You mentioned CPCN requirements. Can you provide a little context for why that's important here?
Sure. So CPCN, the Certificate for Public Convenience and Necessity, is required for most types of generation where the utility has to come in and request that the commission approve that certificate before the facility can be built. And so that allows the public staff and other interveners to have a chance to evaluate the facility at the front end, understand the costs involved, the potential alternatives, and the various aspects of the facility so that there's some review going on ahead of time before the facility is built. And my understanding is that that is not required right now for battery facilities. So we're not really seeing the details of these battery facilities until they're being sought for recovery in a rate case like we're evaluating today.
Thank you. And Mr. Hill, I see you nodding. Is there any?
Presiding Commissioner, before Ms. Kress continues, I just want to note that the entirety of the questions being asked here are essentially de facto friendly cross at this point. There's no areas of disagreement between the public staff and SIGFR's witness on these topics, and we would object on that basis.
Presiding Commissioner McKissick, I was simply asking Mr. Hill if he wanted to expound upon the answer that his colleague, Dr. Weaver, just testified to. So she also testified to the fact that there is a slight difference in position on how best to handle battery energy storage projects and the risk of cost overruns and delays or canceled projects related to BESS. And you heard her say it would require additional internal discussion at the public staff. So there is a slight difference of opinion in terms of the best way to mitigate that risk. And I was simply asking Mr. Hill if he would like to expound upon what his colleague said. And by the way, for opposing counsel's sake, I'll be done after he answers that question.
All right. Well, I'm going to overrule the objection so he can go ahead and provide his additional supplemental testimony on that issue since they're appearing as a panel.
Thank you.
I would just second what Dr. Weaver said. We currently our understanding is that those battery facilities aren't evaluated through the CPCN process and are just evaluated either for cost recovery as a historic project or as an MYRP project.
Thank you. No further questions.
Okay. Let's see. We do have Environmental Defense Fund that was reserved a few minutes. All right, you're going to pass. Any redirect? All right. There are no questions from commission staff. In fact, Attorney Kress addressed an issue that was among issues commission staff had concerns about. Chair Brawley?
Sure.
Any other commissioners have questions? Okay. And this panel can hereby be released at this time. Thank you
so much.
The public staff calls its accounting panel to the stand if it's.
It's
the
fine.
appropriate
Let's
time.
go ahead and get them sworn in. We'll probably proceed with testimony in the morning.
Thank you, Commissioner McKissick. I would note we have 5 witnesses on this panel and we neglected to set up the table in front of that main witness table ahead of time. So
What
we're
we
happy
can
to.
do- We're going to get them sworn in today and begin the testimony in the morning so you can have a table there. Then the only value in getting them sworn in now is that you can say their testimony took 2 days. So come on up and put your hand on the Bible, or if you'd like to be sworn or affirmed, as the case may be. Do you solemnly swear the testimony you about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And if you want to go through any formalities, we can, but beyond that, we will adjourn immediately thereafter.
Okay, that sounds great. I can go ahead and get their testimony in the
Sure.
record. Okay, so the public staff now calls Barry Brown, Syed Imam, Desiree Manful, Hemant Mehta, and Finj Zong, who filed joint testimony as the accounting panel, to the stand. Mr. Brown, would you please state your name, business address, and current position for the record?
Yes, my name is Barry S. Brown. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am a public utilities analyst for the North Carolina Public Staff.
Thank you. Mr. Imam, would you please state your name, business address, and current position for the record?
My name is Syed Muzammil Imam. My current business address is 430 North Salisbury Street, Raleigh, North Carolina. And I'm the public regulatory utilities analyst with the Energy Division.
Thank you. Ms. Manful, would you please state your name, business address, and current position for the record?
Hi, I am Desiree Manful. My work address is 430 North Salisbury Street in Raleigh. I'm a public utilities regulatory analyst with the public staff.
Mr. Mehta, would you please state your name, business address, and current position for the record?
My name is Hemant Mehta. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst with the Energy Division of the public staff.
Thank you. And Ms. Zong, would you please state your name, business address, and current position for the record?
My name is Fan Zhang. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am the public utilities regulatory analyst manager of the Energy Division for the public staff.
Thank you. And I'll direct the rest of these questions to Ms. Zong. On May 29, 2026, did you each prepare and cause to be pre-filed direct joint testimony in this docket consisting of 71 pages, 2 exhibits, and 5 appendices?
Yes.
Did your testimony contain confidential information?
Yes.
On June 18, 2026, did you prepare and cause to be pre-filed in errata with corrections to your joint testimony and exhibits?
Yes, we do.
Do you have any further corrections to your pre-filed direct joint testimony?
No.
If I were to ask you the same questions as in your corrected pre-filed joint direct testimony today, would your answers be the same?
Yes.
Did you prepare and cause to be pre-filed on July 6, 2026, a summary of your joint testimony in docket number E-7 sub 1329A?
Yes.
And have you each reviewed the agreement and stipulation of partial settlement between DEC and the public staff filed in this docket on July 2, 2026, as well as the stipulation of settlement on storm costs between DEC and the public staff filed in this docket on July 6, 2026?
Yes, we did.
And do you support the July 2nd and July 6th stipulations?
Yes, we do.
Presiding Commissioner McKissick, at this time, I move that the following testimony be entered into the record as if given orally from the stand, and that the following exhibits be entered into evidence as pre-marked or simply admitted into the record.
Okay, without objection, your motion is allowed.
And I'll just, out of an abundance of caution, I'll specifically state the pre-filed joint testimony of Mr. Brown, Mr. Imam, Ms. Manful, Mr. Mehta, and Ms. Zong, consisting of 71 pages as corrected, 2 exhibits as corrected, and 5 appendices, and the pre-filed summary of joint testimony of Mr. Brown, Mr. Imam, Ms. Manful, Mr. Mehta, and Ms. Song.
Without objection, your motion's allowed.
Thank you.
All right, it is now 4:58 PM. We're going to adjourn the hearing for today. Oh, okay.
Yes, thank you, Commissioner McKissick. To ensure that I'm allowed back in my office this evening, I do have a motion I'd like to make.
Okay, go right ahead, sir.
Thank you, sir.
Before we adjourn. Okay.
Company witness Justin Teckenbrock, we would move to excuse him at this time. We did confer with the parties. The parties have indicated they have no cross for him. We also connected with commission staff, and commission staff also indicated they have no cross for questions for him. So at this time, we'd move to excuse him from the hearing.
Without objection, your motion's allowed.
Thank you.
And are there any other preliminaries that I need to deal with or any other matters? And we'll get a formal order out relating to that. Okay.
Thank you.
We're going to go ahead and adjourn now until 9:30 a.m. in the morning when we will recommence this hearing. Thank you.